May I kindly mention item number 61 of today's list, my lord.
Ah,
The urgency is this, my lord. I am the lowest tenderer. The learned single judge has allowed the other the tender who are not eligible to be participate, my lord. If they open the tender as per the single judge order, my lord, then my appeal will increase.
appellate side matter.
Appellate side matter, item number 61 of today's list, my lord. Kindly take it up Wednesday, little upgradation, my lord, so that my appeal.
Respondent has been served.
Yes, my lord, I have served. I have given earlier notice. Today also I will give further notice.
To the concerned advocate.
My lord, I shall.
To the council. Wednesday we can make it.
Item 61.
61.
Lordship, may I be permitted to mention, your lordship, I'll be only, this is the pill matter, your lordship, I'll be praying for some upgradation, your lordship. It was appearing as item number 67 and 68 on
What is the urgency in pill matter?
Lordship, the urgency, your lordship. Lordship.
Every Thursday we take up around
Lordship.
25 to last week, 35 fresh matters were there. All 35 we finished.
Lordship.
And then we proceeded with the
Lordship,
upgraded
lordship.
matters. So probably let us see this Thursday what will happen. We'll wait. Please wait for Thursday.
Lordship.
Yes, DHC sir.
My lord, before I mention this matter, my lord, all my best wishes to all the members on this auspicious occasion of the Ram Temple inauguration. I start my argument with this.
But you are here.
My lord, I am here because Lord always says, do your duty, that is your beauty. So therefore I am here. This is my duty. And Lord, that is the people whose duty is to be there, they are there. And we are here, my lord. My lord, I am praying, my lord, for leave to file appeal, my lord, without the certified copy, my lord, of the order dated 17th of this month, my lord. Passed by the Honorable Single Judge, my lord, of constitution of an SIT for investigation in respect of Nazar Police Station case where ED officials were assaulted. While now, my lord, we are challenging a portion of that order, which is with regard to constitution of SIT, my lord, because this is leading us nowhere, my lord, because the state government, state police.
It will come on Wednesday.
My lord, leave has to. My lord will kindly keep it on Wednesday, subject to my lord. And my lord, in the meantime, my lord.
Residue Wednesday.
My lord, will kindly grant leave, my lord, so that I can file it.
Can be granted.
My lord.
Can you serve the?
My lord, I shall.
The advocate who appears.
I shall, my lord. We will complete the service and then only will come before matters. I'm great.
Including the learned advocate.
My lord, we shall.
My lord,
My lord, we will file it today, my lord, pursuant to my lord's direction, and then, my lord, after filing, getting the number, we'll serve it. I'm grateful.
My lord, with your kind leave, I'm constrained to mention this matter for upgradation. It is currently running as item number 993 in the combined monthly list. This is the disability matter, my lord, you will remember. And the urgency is that the second round is about to start. Grateful, my lord.
My lord,
may I have your lordship come on Thursday. Upgraded.
My lord, may I be permitted to mention one application, new application group 9, my lord.
Yes.
Grateful, my lord.
My lord, may I be permitted to mention a matter under the application, my lord?
Yes.
May I have your lordship's kind leave to mention item number 57 of the daily appellate side list, your lordship. It's a tender matter. The urgency is that the work order will be issued. So I'm praying.
The writ petition was dismissed.
The writ petition was dismissed, your lordship. We have been rejected on the basis of a bona fide and inadvertent mistake, basically a clerical mistake, if I may be.
You give, let us see what can be done.
Your lordship.
So, I am appearing in that matter.
Once again, Mr. Gaur. Yes.
On 11th December, your lordship passed an order directing the department to trace out the file. My writ petition was dismissed, referring to another file. Now, till date, nothing has happened. Kindly direct them to reconstruct the file because we are taking advantage of the dismissal of the writ petition. The rampant construction, unauthorized construction is carrying on the vested land.
No. Which file is missing? Appeal file is missing?
No. It's a writ petition. This file is missing. Let's say direct. Kindly see the order. Two order.
Let's say that. Keep it under the caption to be mentioned. And you asked tell the department what is that? Yes, Mr. Gadodi.
My lord, my colleague was just mentioning item number 57, that tender matter, my lord. I am appealing this matter leading him, my lord. The urgency is, my lord, it was a tender for toll collection. And my lord, admittedly, I am the highest bidder by 15 crores of difference of money.
But the only
No,
typographical.
he's given a letter. We'll
Yes.
try and upgrade the matter.
Obliged, my lord, obliged.
ASG wants to mention some.
No, my lord, I am item number 1 and 2 in the original side.
My lord,
Grateful to you.
my lord, item 73 of today's list, my lord, I'm praying for some upgradation. My lord, the urgency is that, my lord, he's a senior citizen, and in 2019, my lord, his tender has been dismissed, and then thereafter, my lord, he completed 99% of the job, but he hasn't been paid, and further his
Let us see what.
Well, only to refresh your memory, last week I mentioned this matter, my lord. In terms of Supreme Court direction, my lord, my PIL matter, this is matter, there is in regard to my PSC, my lord, and my lord is constitution, composition, my lord.
Yes.
Now, my lord, you will have directed that a particular date will be fixed for hearing matter, my lord.
No. This week we can't do it. Probably the week starting 29th we'll do it.
Right.
You give the letter. Give the number at least.
To this,
To the court of.
I am giving just.
My lord, may I leave to mention two applications, my lord. One is mandamus appeal against a police in action, my lord, where we were the private.
Fresh matters, it will come. You
Fine.
please give.
And my lord, one more restoration application
Yes.
in the appellate side, my lord.
Appellate, sir. Yes, he is appellate.
Original say daily list item number 1 and 2, extension of interim order.
My lord, I appear for the appellants.
Yes, sir.
This is relating to, my lord, an order passed by the learned single judge disposing of the petition at the interlocutory stage by mandatory order. Now, my lord, the question involved is whether the tea gardens are entitled to subsidy when applications were filed when the scheme was closed. And those facts were not considered by the learned single judge. And my lord, your lordships are aware that in terms of the rules.
No, the appeal has to be heard.
Yes, my lord. Yes, my lord. Yes, my lord. That is the
When it
prayer.
can be heard.
My lord, kindly fix up a
I am
date.
suffering the, my lord, order passed by your lordship that I shall not insist for payment.
With the leave of. How much time it will take for all of you put together?
May I submit with the leave of learned agency? May I submit one thing? What happened? The learned honorable single judge will not allow the repetition on the very first day. It is a basically money claim. Now, on the very first day, repetition was allowed. But central T-board was directed to pay near about 70 lakhs. We did not use any affidavit. Let the matter be remanded. We shall file our affidavit within 2 weeks. Let it be heard out by the honorable single judge. On the very first day, repetition was allowed. And this is a money claim, my lord.
But the order says
It was after service.
Despite service, none
Yes.
appears for the T-board.
T-board. None appears on the T-board, but your lordship knows, my lord. The
Union
money
was
claim,
represented.
money
T-board
claim
was
matter,
not
my lord, at least an opportunity ought to have been given to the T-board. But basically,
the question involved is when the claim of the tea gardens was rejected, whether actually it is a case when a rejection has been made is decided to be decided on affidavit. And your lordship's rules are specifically clear that 4 weeks time is to be given for filing an affidavit. What prompted the learned single judge, with great respect to him, to set aside the order of rejection and allow the repetition?
Solicitor, only problem is T-board did not appear despite service. Therefore, the learned single bench did not have the opportunity of hearing your submission or whatever your defense.
Well, may I pray for this, my lord, since lordship was asking us how much time this would take. For me, there are two matters. For me, my lord, it would be half an hour. If lordship, and it is only the writ petition.
1 second. Only problem is their affidavit was not filed.
Yes.
In the memorandum of grounds, they would have only said opportunity should have been given,
Yes.
etc.
Yes.
The merits cannot be gone into, or we will be like the court of first instance going into the merits. Why don't we restore the writ petition with a request to the bench to take it up within 2 weeks, and by then if they file,
we shall file it.
My lord, for that also, my lord, I understand what is, my lord, falling from the bench, my lord. But for that also, my lord, possibly the appellant has to demonstrate that if an opportunity is granted, this is the case with which I could have gone to the learned judge. My lord, in the stay petition, my lord, they could have, my lord, at least their version of the story, they could have pleaded that. My lord, what is the matter? 2 minutes I'll take, my lord. It's a scheme. I am a tea manufacturer. I produce, my lord, tea, and based on my production, I get a my lord, quantum of incentive, my lord, under the scheme. Now, the scheme was valid for a particular, my lord, period. I applied within the period. It is only for only a 6-month tenure, apart from the entire 5-year, only a 6-month tenure for which I have been denied on the ground that there was a technical issue at their end for which my application could not be registered. Now, they have themselves admitted that my prior application in subsequent correspondence was not only registered, my entitlement was also admitted. All this was considered by the learned judge, and the learned judge felt that you cannot deny the claim on the ground that by this time the scheme period is over, or that there is some financial crisis on for the, my lord, authority to, my lord, disburse the fund. And after considering all this, my lord, with a reasoned judgment, my lord, the learned judge has passed the order impugned. I can, my lord, appreciate the, my lord, issue which lordship just now, my lord, flagged, that lordships would then be the court of first instance, and it is a risk that the petitioner is taking. My lord, I am willing to take that risk if lordships, my lord, feel that lordships are going to hear it, and if they wish to, my lord, put in a supplementary indicating their stand on record, I can take that risk.
Instead,
My lord, may I just say one thing? My lord, may I just say one thing? Yes. My learned friend is not correct at all. Because kindly see, my lord, the scheme ended on 31st March 2021. And the application for such subsidy was made on 17th November 2021, after the expiry of almost 9 months. And thereafter it was rejected. When by a reasoned order it is rejected, it's a matter to be decided on affidavit by the learned single judge. Even if the T-board could not appear on the first day, his lordship could have given another opportunity to T-board to canvass their case. But I am giving your lordship the dates. 31st March 21 was the scheme was ended. Application was made on 17 November 2021, and it was rejected by reasoned order. My lord, it was rejected by a reasoned order on 28 December 2022, and the writ petition is filed, my lord, long thereafter in 2023, end of 2023. But if my lord set aside the order, remand the matter before the learned single judge, we shall file the affidavit within 2 weeks.
Oh, the order of rejection was passed in 2022.
Yes, 28th of December 2022. And
28th December 2022, rejection as a reasoned order. And that was communicated to the petitioner. And when a rejection order is passed, my lord, your lordships have vast experience.
Within 2 weeks, we will request the judge, the learned bench. Definitely, we have done so in 3 matters, where one Mr. Mainak Bose was also appearing. Now, once again, the matter was heard. Order has been passed. They are on appeal last week.
2 submissions. Kindly records that I had formally...
No. My learned friend is going on and going on. My lord, kindly appreciate.
Right. Yes, sir. Yes, sir.
And my lord, only one, my lord, the request which lordship was saying, if this can be expedited,
Yes,
because...
definitely that means. Heard the learned additional solicitor general appearing for the appellant, and Mr. Ashri Datta, learned advocate, appearing for the respondent writ petitioner. The appellant, T-Board of India and others are aggrieved by the order dated 22nd August 2023, by which the writ petition filed by the respondent herein was allowed. In the memorandum of grounds, the appellants have not dealt with the matter on merits, but would contend that the order of rejection of the grant of subsidy was passed on 28th December 2022, which is a speaking order, and on the first day when the writ petition was heard, the same has been allowed, though when the fact remains that none are represented the T-Board of India. The writ petition was filed before this court on
17th August 2023.
17th August 2023, challenging the order of rejection passed on 28 December 2022. The learned advocate appearing for the respondent writ petitioner would contend that the appellants could have dealt with the matter on merits, so that this court can test the correctness and validity of the order of rejection dated 28 December 2022. In our view, in this appeal, in this intra-court appeal...
One more submission that we had moved it upon service and which is recorded.
in this intra-court appeal, we are to decide as to the correctness of the order passed by the learned single bench on the facts which are available before the learned single bench. However, the fact remains that despite surveys, the appellant board did not appear in the writ petition, and there is some explanation sought to be given for such non-appearance. Be that as it may, since a speaking order has been passed by the appellants on 28th December 2022, it would augur well, AUGUR, augur well, for the appellants to file their affidavit in the writ petition so that the writ petition can be disposed of on merits. The learned advocate appearing for the respondent writ petitioner apprehends that there will be a delay in the matter being heard by the learned single bench. The learned advocate for the respondent writ petition need not have any such apprehension, as we will make a request to the learned single bench in this order for fixing an early date for the hearing of the writ petition. As soon as the after affidavits on opposition is filed by the appellants in the writ petition. For the above reason, the appeals are allowed and the order passed and the writ petition set aside, and the writ petition stands restored to the file of the learned single bench. The appellants who are respondents in the writ petition are directed to file their affidavit in opposition within 2 weeks from date. Reply, if any, within a week thereafter. Let the matter be listed before the learned single bench during the week commencing 5th February 2024, with a request to the learned single bench to dispose of the writ petition at the earliest.
My lord, may I make one
Grateful,
prayer?
my lord.
It is
May I
made
make
clear
one prayer?
that this
May I make one
once
prayer,
once
my lord?
it is made
May-
made clear that this court has not gone into the merits of the matter and has disposed of these appeals
My
on
my lord,
the
may I make one prayer?
for the reasons indicated above. Yes,
My lord, on 5th February, I shall remain at New Delhi to attend the International Attorney General's Conference. So instead of 5th February, kindly make it any other day.
no, we have said in the week commencing 5th February.
Makes it 6th February, my lord, if my learned senior friend has any objection.
Won't be proper. No, we say you hear it on say.
Very well, very well. My lord, we will approach the learned single judge and we'll try and accommodate my learned senior friend as well.
Accommodate.
The same
No,
order
the
will
same
pass
order
back.
in the next matter, item number 2.
Yes, item number 2 also.
Same
My
order.
lord, only one difference would be, my lord, the impugned communication, since lordship has recorded a date here, that date is, my lord, in the next matter, 22nd March 2023, which has been set aside by the learned single judge. So, my lord, that correction has to be.
Second matter, earlier matter is 28 December 2022. Thank you.
I'm so grateful, my lord.
Developed.
Restoration application item number 3 and 4.
Nobody to press the application. Condonation of delay is there. Respondent served. It's a public interest. No. Not today.
New application item number 5.
With endorsement, no such person in the address.
Respondent served.
Lord, there is a delay, my lord, and respondents, lord, have not been served. Lord, served, lord, it has returned unserved. Lord, with the endorsement, no such person at the address.
How can that be? For the income tax department, you can serve on Mr. Om Prakash Prasad. Fresh notice to the respondent to the correct address. In addition, the learned standing counsel for the appellant shall serve Mr. Om Prakash Prasad, learned advocate who appeared for the respondent writ petitioner in the writ petition.
Lord, service through email also, my lord, lordship will claim.
The appellant department is also permitted to serve notice through email to the registered email ID. Next.
Item number 6.
Same order, my lord, because
Same order. Item 6 also.
Grateful.
Item number 7.
7 I am appearing for the appeal.
How many days?
The delay was condemned on the last occasion, 88 days delay was, but it was served, email service has also been effective, but nobody turned up. But on the last occasion, the Lordship's query was that before the CIT appeals, there are several appeals were pending. The Lordship remember that. I have shown a document, those appeals have already been disposed of. This is regarding section 68. There was search and seizure was conducted. So it was served and through email also. That affidavit service has also been there.
Where is the commissioner's order?
May I just indicate? Commissioner's order is at page number 19. Sorry, page number. Page number 19 is, and the relevant portion, Your Lordship will kindly see, that page number 22, Your Lordship's query was, regarding around 10 appeals, which Your Lordship seen, that page number 22 is there, that was on the last occasion, I had given documents which show that those appeals have already been disposed of.
Disposed of means allowed, say, dismissed.
That instruction,
Why these people should give you specific instruction, or rather, you should ask for that.
Yes, we have. But they are saying these are 2021, 22. This documents were exposed. May I file supplementary affidavit enclosing those? We have given only the disposal dates, those were all disposed of in 2021.
The CIT appeals order was an ex parte order.
Was an ex parte order. Civil opportunity was given, but nobody turned up. Before the
even before the
yes
tribunal, nobody appeared.
Yes, that is a difficulty.
We'll send it back to
yes,
CITP.
Your Lordship can send it back.
We'll send it back to CITP.
Mal.
Delay has been condoned.
Delay has been condoned on the last occasion.
This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961 is directed against the order dated December 23, 2022, passed by the Income Tax Appellate Tribunal B Bench Kolkata within bracket Tribunal in ITA number 347/KOL/2020 for the assessment year 2012-13. The revenue has raised the following substantial questions of law for consideration. Page 6, 7, and 8,
yes.
A, B, C, 3 questions.
Yes.
We have heard Mr. Prithu Dorial and Senior Standing Counsel for the appellant. Full stop. Notice has been served on the respondent, but none appears for the respondent. We have perused the order passed by the learned tribunal, before which learned tribunal, by which the appeal filed by the revenue was dismissed. Before the learned tribunal, none appeared for the assessee. On perusal of the order passed by the Commission of Income Tax Appeals, within bracket CITA, dated 29/10/2021, we find that none appeared for the assessee, and the CITA partly allowed the appeal, fixing the net income of the assessee company at 5% of the turnover, and addition to the extent of rupees 2, 15, 85, 391 was alone was confirmed. The learned tribunal, in paragraph 8 of the impugned order, wherein the learned tribunal found that there should be some certain specific instances pointing out as to how only the purchases ACS are required to be added, and that the CITA in the finding CITA has estimated the element of income in whole details based on the details maintained by the assessee. We find that the tribunal has not elaborately given any reasons for interfering with the for rejecting the department's appeal. More so when none appeared for the SSC. Therefore, we are full stop. The same is the position before the CITA, where none appeared for the SSC despite service of notice, and it is also the case before us, where in spite of service of notice, none appears for the respondent SSC. Considering the peculiar facts and circumstances of the case, we are of the view that the appeal has to be reheard by the CITA after serving notice on the SSC. For the above reasons, the appeal is allowed. The order passed by the tribunal is set aside, as well as the order passed by the CITA dated 29/10/2021 is set aside, and the matter stands remanded to the CITA for fresh consideration of the matter on merits and in accordance with law. Consequently, the substantial questions of law are left open. Next.
Grateful.
For admission, item number 8 and 9.
8 and 9 are interconnected, Lordship. In 8, the party has preferred an appeal against the order passed by the learned tribunal. In 9, the department has preferred an appeal against the said
It is
order.
vice versa.
Vice versa. Lordship, only one difficulty, Lordship. In
They have
9,
not served upon us.
in 9, my lord, I have instruction to appear on behalf of the department, but I have not received the papers. If your Lordship kindly takes up this matter next week, Lordship. In the meantime, we will also serve upon them, or any date as your Lordship is convenient.
The learned advocates for the appellants are directed to serve papers on the counsel appearing for the respondent. Let the matter appear under the same caption on so and so date. Next.
Item number 10.
My lords, appearing for the appellants, my lords, I am praying for 2 weeks' time since the stay application, my lords.
Just turn around. There are nobody in the court.
My lord,
We have to have some work. You open your brief. Where is your file?
my
Episode, nobody is here.
In fact, before the other division bench, their lordships have finished the work and they have gone.
Court number 4 also. All matters called on. None is there. This parking will stay fixed.
Yes, morning when I came, I saw that.
My lord, since there are some documents, the written submission which was submitted before the tribunal, we are yet to receive. The client is out of town. It's a small prayer, my lords. See.
All right. At the request of the appellant, learned advocate for the appellant, adjourn.
Intercourt appeals, item number 11.
This matter, my lord, Mr. Obrutosh Mojumdar, because of some difficulties, he's unable to attend court. My lord, I'm humbly praying for
It's not in West Bengal.
My lord. My lord, for 1 week, my lord.
My lord,
My lord,
11
next
and
week,
12
my lord.
are related matters, my lord.
11 and 12. my
All
lord.
right. As jointly prayed, adjourned.
Next week, my lord.
Next.
Item number 13.
Next week, second February.
Item 13, my lord, Mr. Amal Kumar Banerjee is the learned advocate on record. Due to illness, he could not come. I am told over telephone that he engaged as his leader, senior advocate, Mr. Kishore Datta,
So now, my lord, has been.
who is has taken the
Barbara
charge of
told
the.
me to appear, so I will get some time.
The respondent has been served.
Yes,
Yes, yes.
Service
Service is complete.
Lordship, I am praying for not today on behalf of the respondents, WBSIDC.
You are appearing for the state.
No, WBSIDC Corporation.
You are the contesting respondent.
Yes.
Yes.
As at the request adjourned. Next.
Item number 14.
You will give the date.
My lord,
If 2 weeks possible, my next week is a holiday.
Okay.
my lord, I am appearing for the respondent, my lord.
Any convenient.
Very.
You please. Item 14.
My lord, I am appearing for the respondent. My lord, we have not received. Take your breath.
Other side কোথায়?
I was about to say this, that's what I'm going to talk about that.
Yes. You are
For the respondent writ petitioner, the copy of the appeal has also not been served upon us.
That show cause notice covered the period only 1890.
Only that. And that was there in the show cause notice itself. It referred to a particular list of employees who
And
had
in
come.
the memorandum, what do they say?
But we haven't been served with anything.
Oh, you have not been served.
Not been served with the, not been favored with the copy.
And the learned bench fixed a time limit for payment by 12th January. They have not.
They haven't paid. My instructions are that we've given them a letter for compliance, but they haven't paid that. And the show cause notice is absolutely clear. It says, the show cause notice reads that for these many years, number of patients were X, you were paying Y. For this 18-19, it's gone up by 30%. And they've alleged certain discrepancies in how we apparently did not. Anyways, that's on merits. It identifies a list.
But today he is not there. Let us.
No, I understand. I don't want to steal a march unnecessarily.
I will say not today. Or list none appears for the appellant and list next week. You just contact him and get the.
I'll do that.
Next.
Public interest litigation, item number 15.
My lord, I am for the petitioner. My lord, the advocate for the petitioner, Mr. Srikanth Dotto, has not come to the court yet, and that's why I'm praying for not today only.
But it's a 2021 matter.
Yes,
What
my-
is the matter about?
Because I have no instruction, my lord, and that's why I only pray not today. Not
The
today.
problem is not today is easy to ask, but on the next day, then once again you will see for upgradation, etc. Somebody mentioned this matter.
I don't know, my lord. I have no instruction. Item number 15. Item number 15. Item number 15.
Oh, this is the town vending committee.
Town vending committee. My lord, take it some other day, my lord, because I could not bring my brief today. I was not reported that matter is in the list.
But these hawkers are creating a big problem. Newspaper reports every day, in spite of the learned mayor issuing some directives, they are defying that.
No, my lord, whatever your lordship has given directions, my lord, we took certain actions, my lord. That was reported. There was, my lord, subsequently I submitted a report to your lordship that there was an occasion to go into that, my lord, the report. Your lordship takes it up and the next occasion and looks into that report.
At the request of the learned advocate.
I submitted that report earlier occasion.
Give a date after 3
and
weeks.
they say, my lord, that they will take exception to this report earlier.
Okay. You file exception to the report.
The matter will appear, my lord.
Matter will appear on
5th February.
5th February. In the meantime, I shall file the exception. Grateful, my lord.
For hearing, item number 16.
My lord, in this matter, Mr. Roy Chaudhary is appearing. He's on his legs in courtroom number 12, my lord. So kindly make it not.
I am appearing for the appellate, your lordship. On last occasion, my lord, on 8th January 2024, my lord has granted stay on the issue that the notice has to be issued by the faceless manner, your lordship, but it was issued by the jurisdictional assessing officer. My lord has,
on some date we have fixed all those matters.
my lord, 5th of February, my lord, 5th of February.
Oh, sorry, the 15.
We'll tag this along with it. Actually, there are 3 appellate side matters where senior advocate Harish Salve is appearing, Mr. S.N. Mukherjee is appearing.
My
Mr.
lord.
Ranjit Muraka is appearing. We'll
Girdhar
club
Gopal Dal, my lord.
your matter also along with that.
My lord, deeply obliged, your lordship.
Hmm? Tag this. List this matter along with the APOT number so and so, which are appellate side matters on so and so date.
Deeply obliged.
What to do?
Ordinance monthly list of January, item number 36.
For the appellant, my lord.
What
My
is
lord,
this?
earlier there was a direction to serve notice. I had already served. The affidavit of service was filed, my lord. Despite of that, nobody is appearing on behalf.
What is that 68?
My lord, here the issue is it is relating to the reassessment proceedings, my lord. The tribunal had paused the proceedings on the premise that the approval was notice under section 148 was issued before taking approval. My lord, kindly come to page number 33 and 34. At page 34, my lord, this is the approval.
34.
Yes, my lord. In this letter, my lord, there is a stamp 31st March 2017. So tribunal had held that this approval was received on 31st of March. But the notice was issued on 29th of March.
On that ground, it quashed.
Is quashed. But my lord, kindly come into page 33.
33. Yes.
Bottom, my lord. This is the note sheet. 29th of March 2017. The assessing officer has written that he has received the approval.
No, this is actually the receipt only. The seal is receipt.
Yes, my lord. My lord, sometimes the approvals come various ways. So this letter might have come
simultaneously on the same day. But whether this record was placed before the...
This is the part of the order, my lord. I am showing this letter.
No, how does the tribunal consider the page 33 communication?
My lord, this is in the tribunal's order, my lord.
Oh, tribunal's order?
Yes, my lord.
What is the finding?
My lord, the findings are page 39. But page 40. On merit, my lord, there's a finding at page 42. And at page 40, my lord, this is a finding.
No. What the tribunal says at para 7.1.
7 point. This is
this was received by the AO only on 31st. So he could not have...
Yes, my lord. That's why I have shown that noting, my lord. That noting was made by the assessing officer at page 33.
This is wrong. This date seal also says contents not verified in that.
Yes,
chapter.
my lord.
We have heard Mr. Amit Sharma, learned as standing counsel for the appellant. No notice has been served, none appears for the respondent. Assessee. The appeal is admitted on the following substantial questions of law.
Page 9, my lord.
Page 9 and 10, question A and B. Then the usual formality.
Item number 37.
I'm grateful.
I'm appearing on behalf of the respondent in the matter. But actually, the matter entails two transfer pricing issues. Your Lordship, one is pertaining to corporate guarantee, the other is pertaining to Section 80IA. Your Lordship, the issue of 80IA, in my humble submission, Your Lordship, tribunals refer to Birla Corporation. My Lord, in item number 4041 has similar issues where Your Lordship, my learned senior is appearing in the matter. But I have the advantage of having the learned
So we
senior
can
advocate.
hear 4041, then we can hear you.
And with the other issue being corporate guarantee, Your Lordship, that is
So
not
we will
common.
shift this to February monthly list. All the three matters. 40, 41 and 37.
Appearing in court with Mr. Smita Das.
I am not in 4041, Your Lordship.
Mr.
My senior is
Khaitan appearing, Lord. Your Lordship is fixing the matter in the month.
Madam is there.
Yes. 4041.
37.
I am led by Mr. Smita Das.
Madam, item 40, 41, we will hear your matters along with item 37 in February monthly list.
The only one thing, my Lord, I can, if I may indicate, my Lord, I've been told by the junior advocate appearing in item 4041, Your Lordship, that pertains to a subsequent year having a transfer pricing issue, wherein the tribunal has relied on Birla Corporation's own case, the assessee's own case, for assessment year 11, 12, 12, 13.
Then what we'll do is, we will adjourn your matter to February.
Yes.
Or my Lord may tag it if that may, because one issue is separate.
But are you ready today?
Mr.
Mr. Khaitan is arguing before the court number 12.
What he's indicated, Your Lordship, is that
Smita Das, I'm led by Mr. Smita Das. Smita Das is leading me.
Or a not today.
Smita Das is leading me in that matter, my Lord, item number 40 and 41. Your Lordship. Your Lordship,
The only thing,
tag the
40,
matter.
41.
Yes.
Pass over. All right, we'll say pass over.
Pass over.
If time permits, we will see.
My Lord.
37 pass over, 40, 41 also pass over. You call 38.
Item number 38.
38, Lord, I have been instructed to appear for the department respondent, my Lord, but I don't know the.
But actually, on the previous occasion, my learned senior was leading me in the matter. On the previous occasion, Your Lordship, an order was passed by my lords, wherein Mr. Om Narayan Rai was also instructed, I believe there was an instruction to that effect, that his appearance may be regularized along with Mr. Somen Bhattacharya. Accordingly, Your Lordship, we've given them a brief 38 in intent.
Okay.
But in this matter, being led by my senior.
But I have been.
देख लीजिए आप बात में बोल दीजिए I may pass over if I believe there is some confusion.
But the delay was not condoned.
For the tribunal, Your Lordship, if I may indicate, this is a case of an assessee wherein Your Lordship, his matters have been very badly managed. What has transpired, my Lord, is that in this case, the assessee had preferred an appeal. He had filed an appeal before his assessment was going on. Unfortunately, Your Lordship, the notices, they were sent to the old address. So he did not participate in the assessment proceedings. Before CIT appeals, Your Lordship, what had transpired, Your Lordship, was that the initial notices were sent to the new address. Assessee participated, provided the new address in the adjournment letters. After 1 year, another notice is sent by CIT appeals. This time again, probably to the wrong address, Your Lordship, because the order has been passed on the wrong address. Now, Your Lordship, what has happened is that the assessee was dependent on one chartered accountant who was a tax consultant. Assessee was under the impression that he would handle the entire appeal. He passed away. Assessee wasn't aware that the appeal wasn't preferred before the tribunal. When assessee gets calls for recovery, he approaches, he finds out he's passed away. He obtains a death certificate and files an affidavit before the tribunal in a condonation of delay in the form of an affidavit, Your Lordship. And even before the tribunal, Your Lordship, some issue had transpired. Here, the new consultant, he had to undergo some surgery. He could not appear. He asked someone else to appear on his behalf, an advocate. He appeared before the tribunal in around 15th or 16th of January. He asked for time to file paper book because, Your Lordship, all along matters had been done ex parte. The tribunal gave him a 10-day extension, a 10-day limitation, recorded some adverse remarks, made some adverse remarks. And on that day, that advocate did not appear. My Lord, the assessee was unaware. But we can only humbly submit, your lordship, that this matter is one where there has been some lapse on the part of the assessee. He should have been more vigilant as well. But
Where is the assessment order?
my lord, the assessment order, my lord, at page 93. But it is at page 145, my lord. The assessment order, my lord, the tribunal. The assessment order is at page 86, my lord. अच्छे तो
Where is the assessment order?
It's at page 80. The stay was filed. I had prepared it, my lord. I had filed it, your lordship. There's some.
Nine 27 days
Malo.
in filing the appeal before the tribunal.
Malo.
Tribunal referred to Supreme Court judgment, etc. Dismiss.
Malo.
You pay some cost.
My lord.
Not to the department. Income tax department, no pay. Not a single pay they will get. To SLSA, you pay.
My lord.
How much?
As my lord deems fit, my lord. Because
1 lakh.
My lord. Whatever amount that my lord deems fit, because your lordship, this is a case where he's not handled the affairs properly.
Subject to that condition, we will set aside the order, send it back to the tribunal.
I would be grateful, your lordship.
And we'll condone the delay also.
I would be
so that
grateful.
the appeal can be heard on merits. Huge addition.
My lord.
Because total income has been determined as 52 crores. Huh?
Around 54 crores and gross tax around 17 crores.
So 5 lakhs also you can pay.
I will leave it to my lords. My lord. The assessee is not been. It's
what do they do?
This is actually a part. This is actually somewhat. I think it's a part of some group. From what I understand, your lordship, probably into real estate. I'm not 100% sure.
It
but
says
into real estate.
Intent infra projects.
It's into real estate, your lordship. It's a part of a real estate group. My lord.
Some assessing officers have got the good habit of writing something about the assessee.
My lord. My lord.
First 3 lines they'll say, assessee is a company registered so-and-so or a partnership firm, engaged in the business of real estate, engaged in the business of manufacture of so-and-so components. This appeal by the assessee, filed under section 260 capital A of the Income Tax Act 1961, within bracket the act, is directed against the order dated 24th January 2023, passed by the Income Tax Appellate Tribunal B Bench Kolkata within bracket tribunal in ITA number 38/KOL/2022 for the assessment year 2012-13. The assessee has raised the following substantial questions of law for consideration. Page number 7 and 8, questions 1, 2, and 3. We have heard Mr. Senior is appearing. JP Kaitan and Senior Advocate appearing for the appellant and assisted by Mr. Prithviraj Jhunjhunwala, learned advocate appearing for the appellant assessee, and Mr. Prithu Doria, learned senior standing counsel for the respondent department. The learned tribunal, by the impugned order, dismissed the appeal filed by the assessee as being time barred, as there was a delay of 927 days. We have elaborately heard the learned senior advocate for the appellant as well as the learned senior standing counsel, and also perused the order passed by the learned tribunal, which has extracted the affidavit filed on behalf of the appellant assessee by its director, seeking to wherein an explanation has been offered by contending that the chartered accountant who was engaged in the matter had passed away, and subsequently the advocate who was engaged had not taken diligent steps, resulting in not pursuing the matter within the resulting in the delay in filing the appeal before the tribunal. Considering the fact that the assessment is a high-pitched assessment, and also taking note of that the appellant assessee should be granted an opportunity to put forth their submission on merits. We are inclined to exercise discretion in the matter, subject to certain conditions. For the above reasons, the appeal is allowed and the order passed by the tribunal is set aside, and the delay in filing the appeal before the learned tribunal is condoned, subject to the condition that the appellant pays a sum of rupees 5 lakhs to the West Bengal State Legal Services Authority. Upon such payment, the receipt shall be filed before the learned tribunal, and the learned tribunal, on being satisfied that the condition imposed by this court has been complied with, shall take up the appeal, namely ITA number 38/KOL/2022 for the assessment year 2012-13, hear the appellant and pass orders on merits and in accordance with law. The appellant shall not seek for any adjournment and shall appear before the learned tribunal on the date so fixed by the tribunal.
And I'm grateful, Your Lordship.
The amount directed to be paid shall be paid not later than 16th February. 16th February 2022.
Let him serve.
Consequently, the substantial questions of law are left open. Next.
I'm grateful, my lord.
Item number 39.
Department's appeal, Lord. Lord, in this matter, Lord, there were, Lord, huge cash sales. Lord, this is a footwear shop. Lord, it managed to have, Lord, cash sales to the extent of, Lord, around 1.5 crore, Lord, during the period of demonetization, Lord, and in a particular month. Lord, the assessing officer, Lord, added the, Lord, sales transaction, Lord, cash sales, Lord, as unexplained income. Lord, the appellate order, Lord, the appellate authority, that is the commissioner, Lord, agreed. The tribunal, Lord, has reversed it, saying that if you have not disbelieved the books of accounts, the addition cannot be made. This is the long and short of the matter, my lord.
That's the only ground.
That is the only ground.
That the books of accounts of the assessee have not been rejected, and the sales have been accepted. And in view of the case law related, we do not find justification lower authorities making the impugned addition. Let us see the order of the CIT appeals.
Yes, my lord. Lordship will kindly see, my lord. It's a long order, my lord, very long order. It begins from page 17. My lord will kindly take, my lord, page 74. My lord, he has, my lord, gone into the facts, my lord, fully. Page 74, my lord. From a perusal of the sales register, it is seen that there are 20 to 30 regular customers. It is noticed that most of the said customers purchase shoes from assessees on day-to-day basis. Since it looks rather strange that some same customers made cash purchases almost on daily basis, the appellant via letter dated such and such was asked to furnish addresses of the customer. Reply was received on such and such. On perusal of the reply, it is seen that many customers who allegedly bought shoes in cash from customers are located at very far off places from office and alleged factory addresses of the addressee. The following parties with the addresses mentioned against their names made frequent purchases in the month of October 2016. Now, my lord, the chart is given. My lord, your lordship will see, my lord, the number of days on which the particular purchase have been done. Thereafter, my lord, on the next page, page 75.
They are a very big famous shoemaker, is it? Sales parties located in Alipurduar, Cooch Behar, and Jalpaiguri. Humanly impossible to come to the assassin and carry it out. Many of the alleged purchases are having address in Kolkata. Most of the parties alleged made purchases from Assi almost on all working days. Not credible that even so and so. Claim to have, but this is of no help to the assessee. When so many improbable entries are there in the sales on a month of, that is month preceding demonetization. In this regard, stated manufacture special suit puja designs of chapels and shoes gone up during puja season. What was their return of income for the previous assessment years? Was that placed before the tribunal?
Lord, that is not there. That is not there, my lord. The tribunal's order is
But
not only.
sir, the cash sales, the onus is on the assessee to prove.
Your Honor, just, my lord, 5 minutes you.
No.
My lord, please come to the assessment order first.
Yes.
My lord, it was a case where they have given me notices in the computers, and your lordship will see how many dates from which the assessment has started. From 19/11/2018, 20/11/2019, 14/11/2019, and my lord may come to the first paragraph. Notice under 142(1) of the IT Act dated 5/8 was issued and served upon the assessee by email. In response to such notices, the assessee furnished his paper, documents, and explanations electronically, and the same has been examined. So I have given every address. I will just come to that, your lordship, where the CIT appeal is agreed to that. Your lordship, then what he does on 24th of December, because 31st December was the time bird, he issues me a show cause notice, not about sale purchase, because I have given him the sale purchase register, the VAT, everything I have given, which is the CIT appeal. Lordship, I'll come and show you. That is not asking. He is asking what, your lordship, it is seen from the documents that you have shown your yearly sales in the month of October such and such, which is made by cash, and out of the sales you have deposited such and such amount to the bank, and you are requested to supply the reply by 26th. So 2 days, 2 working days, and he passes the order on 27th. Your lordship may now come to the CIT appeals order. Your lordship may please come to page number 19.
Yes.
The CIT appeal agrees to this also. What I have furnished: copy of trade license, copy of rent agreement. I'm a manufacturer. I'm not a. I'm sorry. The other side has, I think, has not seen this page. I am a manufacturer. I am not a reseller or trader. And your lordship will see copy of trade license, rent agreement, invoices for import of plant and machinery which I have in the factory, electric bill in this month. I have given before the AO, before the CIT appeal, before the tribunal, that in this month the electric bill was very voluminous. I have given in the paper book, and I have the paper book also. Where can I show that in that month? Because in Bengal, the basic thing is everything is all around pujas. Your lordship has seen in 2 years in Kolkata, the whole industry, the whole industry depends of the Bengalis, or even the people staying here who are not even Bengalis. They really purchase in the month of this puja. And this October was a month of puja where I have made sales. And I have given, your lordship will see VAT registration certificate, bank statement, audited balance sheet, sales register, sale invoice, VAT returns, summary statement of sales as per VAT, copies of VAT challans, copies of stock register. What, your lordship, I can give more. The AO has not done a single 133.6, not a single 131 to the party. Your lordship, what happens, these traders have their agents in Kolkata. So they are not big people. So they will buy according to their needs. How much they sell, the next day they may buy, maybe 3 days after they will buy. So this is the practice in this city, because this is not a very rich city, your lordship. And secondly, in the Durga Puja time.
No. Don't say it is not a rich city. Throughout the country, the maximum number of section 68 cases is in West Bengal.
Your Honor, your lordship, my
of cash. There's so much
demonetization, I have not made any sale. They have not said that I have made any sale in the demonetization period and shown that.
just prior to that. October.
Yes. So, your lordship, I was not aware the demonetization would come. So I have filled up the VAT returns in time. I have done everything.
In fact, the tribunal
Yes.
could have.
I have given this paper book, your lordship.
They didn't discuss anything, sir.
Because
that paper book, if they had discussed, at least sample 4 or 5.
They have. Your lordship will see.
You see the tribunal's order?
Yes, your lordship.
Finding is only in page 8.
Your lordship,
80.
but they have seen these papers. Page 78.
Correct, sir. Suppose we say we have perused the documents and we are satisfied with the case of the appeal allowed. Will you agree with that order?
Your lord.
So therefore, the tribunal is the last forum which can reappreciate facts. You have taken so much of labor and filed so much of documents.
Yes, lordship, I have filed everything.
And it says, considering the aforesaid circumstances and documentary evidences furnished by the SSC, that the books of accounts of SSC has not been rejected, the sales have been accepted. We view the case law, we don't find any justification. Actually, the order passed by the CIT appeals, he has extracted all your sale details, including your invoice numbers.
I have given it,
Yes,
your lordship. I have given before the AO itself.
So, when the tribunal is reversing that order, it should at least do some sample verification.
Lordship, we can only argue. We cannot ask the members to write the orders how they will write, your lordship. We can only assist the bench.
We will send it back to the tribunal to examine the document and come to a conclusion. This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961 is within bracket the Act is directed against the order dated 16/3/2023 passed by the Income Tax Appellate Tribunal A Bench Kolkata within bracket Tribunal in ITA number 427/KOL/2022 for the assessment year 2017-18. The revenue has raised the following substantial questions of law for consideration. Page 6 and 7, question A, B, D. We have heard so and so. The assessee filed its return of income for the assessment year under consideration within bracket AY 2017-18 on 18th of January 2018, declaring a returned income of ₹6,51,620. The assessee is engaged in the business of manufacturing and trading of foodfare. Full stop. The case was selected for scrutiny. Notice under section 143 within bracket 2 dated 9/8/2018 was issued, and subsequently notice under section 142 within bracket 1 dated 5/8/19 was issued, and in response to such notice, the assessee furnished certain papers and documents and explanation submitted electronically. Thereafter, show cause notice was issued on 24/12/2019, stating that from the documents produced by the assessee, it was seen that the yearly sales in the month of October 2016 was rupees 1,66,56,727, which was made by cash, and out of those sales, the assessee had deposited rupees 1,49,54,000 in cash into 3 bank accounts during the demonetization period. Therefore, the assessing officer was of the prima facie view that the assessee received money from undisclosed sources, and they wanted to account for the said money by showing sales which were alleged to be not genuine. The assessee therefore was directed to show cause as to why the deposited money of rupees 1,49, 54, 000 should not be treated as undisclosed income and added back with the total income. The assessee was directed to upload the reply within 26/12/2019. The assessing officer, while completing the assessment under section 143 within bracket 3 of the Act, by order dated 27th December 2019, records that no reply was uploaded by the assessee in response to the show cause notice. Accordingly, the said amount was added back to the total income of the assessee. The assessee preferred appeal before the Commissioner of Income Tax Appeals. No, before the National Faceless Appeal Center. The appellate forum, by order dated 27/6/2022, dismissed the appeal, largely on the ground that that the assessee claimed the sales only during the month of October 2016, that is the month preceding the demonetization. The assessee's explanation. The assessee's explanation that they manufactured special puja designs of chapels and shoes, and the sales were done during puja season in West Bengal was considered, and the CITA and the appellate forum concluded that the claim is unrealistic. Further, the appellate forum held that most of the receipts from cash sales, that is rupees 1,49, 54, 000, out of rupees 1,58, 63, 555, effected in the month of October 2016, was still available for deposit in banks after demonetization was announced. Further, the appellate forum doubted as to how the assessee was financing its alleged business operation without spending the alleged cash receipts. Further, on examination of the bank account, a bank statement of two of the bank accounts maintained in Bank of Baroda and State Bank of India, it was seen that the deposits of demonetized cash were immediately followed by transfer to other bank accounts, and most of the transfers of deposited cash were to Ashoka Hawaii and Shoes Private Limited. Therefore, the claim of the assessee was held to be palpably wrong, and the appeal stood dismissed. The assessee carried the matter on appeal to the learned tribunal, and by the impugned order, the learned tribunals allowed the appeal. It is the submission of the learned advocate appearing for the respondent assessee that a voluminous paper book was filed before the tribunal containing all records, which were perused by the tribunal, and thereafter the appeal was allowed. On going through the impugned order, we find the discussion is in paragraph 5 of the impugned order, wherein the tribunal holds that after considering the circumstances and documentary evidence furnished by the assessee and the books of accounts of the assessee having not been rejected and the sales have been accepted, the tribunal did not find any justification on the part of the lower authorities in making the additions, and accordingly deleted those additions. In our considered view, since the learned tribunal is the last authority which can appreciate and reappreciate factual position, the explanation offered by the assessee, supported by documents, are required to be considered, and the consideration should be reflected by way of certain observations and findings in the order to be passed. Since we find that no such specific finding has been recorded by the learned tribunal, we are of the view that the learned tribunal should reconsider the matter, examine the voluminous records which have been filed by the assessee before the learned tribunal, and thereafter examine the correctness of the finding recorded by the CITA, more particularly the findings in paragraph 4.3 and 4.3.1. For the above reasons, the appeal filed by the revenue is allowed, and the order passed by the learned tribunal is set aside, and the matter is remanded to the learned tribunal for fresh consideration in the light of the observation made above. Consequently, the substantial questions of law are left open.
Your Lordship, out of the court. This type of orders, SECs has to bear so much of cost. You see, I have argued thoroughly these writing in the first page.
Since we have restored the appeal,
Yes. You don't want to give any
no,
specific.
you need not file any additional set. The old file will be there. With that, they can do it.
I'm not saying that, Your Lordship. We argue hours together. We show each page. Then they write such flimsy orders.
Because
they could not find any defect.
The CIT appeals says that the cash to transferred to another account.
That is my concern only, my bigger concern. Your Lordship was set asiding. That's why I did not want to
let it
elongate more.
No. Now you will succeed once more with a better order.
Grateful. Grateful, Your Lordship.
40-41
Yes,
pass
my
over.
lord. Pass over matter item number 40.
40 and 40.
Matter, I am led by Mr. JP Khaitan. So before my learned friend starts, this appeal is relating to assessment years 2013-14 and 2014-15. The tribunal followed its order for the assessment years 2011-12 and 12-13, my lord. We do not know whether the department has come up against those years. So I am praying that let my learned friend be take instruction on that whether any appeal was filed or not.
Apart from the issues in 11, 12, 12, 13, there are no other fresh issues.
No.
No fresh.
No.
But in your grounds, have you said that you have filed an appeal?
No,
Against,
that is also not
we have
my
not
humble
mentioned.
submission.
you can verify?
We have to ascertain from the department, my lord, with regard to.
They should see whenever they are following the earlier order, that should be our first ground. We have filed an appeal. The department has not accepted the judgment. We are in the process of filing an appeal. See, is verbatim extracted the entire order.
Yes, tribunal just follow the earlier years.
Page 93, my lord.
Para 9.3.
Because there are many other appeals of this particular SSC, my
What
lord.
is the
Whether that
question, sir?
pertains to 11, 12, 12, 13, that.
This is a corporate guarantee.
No.
No, not corporate guarantee.
This is deduction of
All right.
80
Page
IA.
7, my lord.
We have heard.
There's a delay of 38 days, my lord.
Delay already.
That is condoned, I think.
Yes, already.
We have heard Smita Daste, learned advocate, appearing for the appellant department, and Mr. JP Khaitan, learned senior advocate, appearing for the respondent assessee. The learned tribunal in the impugned order has followed the decision of the assessee's own case for the assessment years 11, 12 and 2012-13. The impugned orders pertain to the assessment year 13-14 and 14-15. In the memorandum of appeal, the revenue is not stated as to whether the decision for the assessment years 11, 12 and 12-13 has been accepted by the department, or whether they have challenged the same by filing an appeal before this court. The learned advocate appearing for the appellant department is directed to get specific written instructions in this regard. List the matter in the monthly list of February. Next, this will be same order in
40,
40 and
41. Yes, only the assessment here is different. Item number 42.
42, Smita, you are appearing?
No, no.
Someone. 263.
Yes, but here is the issue of the share value is 10 rupees and premium is 90 rupees and the share premium by the SEC rupees 14 crores and odd. Lord, the Your Lordship kindly see the
On what ground tribunal set aside? Such a big order it is written.
tribunal set aside mainly ground that the 133(6) notices. Some subscriber company they have appeared, but the case before the assessing officer that the assessing officer did not verify any document. Page 11, Your Lordship kindly.
Respondent served?
Yes, my lord, respondent sir. I have filed the very service, my lord.
Huge amount. Where is the CIT appeals order?
No, not CIT appeals, my lord, it is 263 proceeding.
Oh, sorry, 263.
That is, my lord, page 10. Page 10, Your Lordship kindly see me page 11, first paragraph and second paragraph.
We have heard Mr. Soman Bhattacharya and Senior Standing Counsel for the appellant. Notice has been served on the respondent, but none appears for the respondent. Appeal is admitted, A, B, C, page 6.
But paperwork may be not dispensed with, my lord.
Filing of the informal paper book is dispensed with, and the stay application shall be retained. Next.
Item number 43.
Matter being led by senior Mr. J.P. Khaitan, Your Lordship. In this matter, Your Lordship, my senior had asked us to prepare a supplementary affidavit, Your Lordship, because what has transpired, Your Lordship, is that the assessing officer in his order has recorded the assessee appeared, filed documents. Subsequently, he writes that no compliance has been made. So in order to ascertain what was filed before the assessing officer, Your Lordship, he asked us to obtain this copy of the records. That, Your Lordship, we request, Your Lordship, we may be allowed to file that in the form of a supplementary.
Who will appear for the department?
Earlier in this matter, my learned friend Mr. Somen Bhattacharya and Mr. Om Narayan Rai, Your Lordship, their appearance was regularized by my lord.
Then you serve copies on that.
I give a copy right away, my lord.
All right. The supplementary affidavit has been filed by the appellant as a C, copy of which has been served on the learned standing counsel for the department today.
This appeal has been admitted by the
No, my appeal has not been admitted yet.
No.
It was adjourned, Your Lordship, on the previous occasion because none appeared on behalf of the department despite service.
You get instructions on this supplementary affidavit. Liberty is granted to the respondent department to file affidavit in opposition.
It's only
affidavit in opposition if they so desire. List the matter in the monthly list of March.
Well,
next.
I'm grateful, Your Lordship.
Item number 44.
Pursuant to my lord's direction, I had served notice, my lord. It was served.
He is an individual assessee.
Yes, my lord. Deposits made during demonetization.
They just followed that Senko Alankar.
But the facts are different, my lord, from the Senko Alankar's case. Here, my lord, in this case, the assessee did not produce the books of accounts. This is the categorical finding of the assessing officer.
Respondent has been served.
Yes, my lord. On it was served on 28.
One Mr. Siddharth Agarwal appeared
in the
tribunal.
tribunal. My lord, kindly come to page 11. In the
But you please come to
my lord.
Page 17. 34
Yes, my lord, the CIT is finding. CIT says the books were uploaded, but here assessing officer says no, books were not produced. My lord, that's why I have shown, my lord, this page 11, my lord. I was coming to that page. Further, no books of accounts like cash book, purchase ledger, sales ledger, etc. was furnished till date. After giving
but unnumbered second para you come. Instant case seen AO unless the books of accounts are not produced. Appellant demonstrated the books of accounts books were uploaded and in the portal from time to time. Seen the tax audit report that the complete set of book is maintained by the appellant and the same are audited by chartered accountant. All details are asked for uploaded in the portal from time to time. AO has nowhere pointed out the uploaded were not correct or complete, or that the method of accounting or accounting standards notified not. Assessment on one, there is a tactic admission on the part of the AO that the books were properly maintained. In view of whole, the rejection of books is not sustainable.
My lord, this is the finding of the CIT appeal.
Yeah.
But the assessing officer, what assessing officer?
No, that he says it is factually incorrect.
Here, my lord, the CIT appeal has stated that assessing officer accepted the books of account. What is the gist of this finding? But the
No, page 11, last paragraph.
Yes, sir.
Since assessee has also not furnished all books of accounts in support.
My lord. In
No
support
question of loss. Please come. This appeal
books of account is hereby rejected, my lord.
All right. This appeal by the revenue filed under section 260 capital A of the Income Tax Act 1961 within bracket the Act is directed against the order dated 16th May 2023 passed by the Income Tax Appellate Tribunal C Bench Kolkata within bracket Tribunal in ITA number 8/KOL/2021 for the assessment year 2017-18. The revenue has raised the following substantial questions of law for consideration. Page 6, 1 and 2. We have got so and so, so and so. The appeal filed by the revenue before the learned tribunal challenging the order passed by the Commissioner of Income Tax Appeals 15 Kolkata within bracket CATA dated 23/9/2020 was dismissed. The we have perused the order passed by the CATA and we find from in the case has been discussed in paragraph 5.4.6 of the order passed by the CATA dated 23rd September 2020, from which it is seen that the CATA has examined the factual position and pointed out that all the details as called for by the assessing officer were uploaded on the portal by the assessee from time to time, and the assessing officer has not pointed out that the accounts produced/uploaded were incorrect or incomplete, or that the method of accounting or accounting standards as notified have not been regularly followed. Furthermore, the CIT on facts held that in the assessment order passed under section 143 within bracket 3, there is a tactic admission on the part of the assessing officer that the books were properly maintained. Therefore, the CIT came to the conclusion that the rejection of the books of accounts was not sustainable in law. The other grounds which are urged before the CITA were also considered and decided in favor of the assessee. The learned tribunal re-examined the facts and agreed with the finding of the CITI. The tribunal also relied upon a decision of a coordinate bench in the case of ITO versus Senko Alanka in ITA number 10 of 10/KOL/2021 dated 27/6/2022 and dismiss the appeal filed by the revenue. Thus, we find that the matter revolves entirely on facts and no question of law, much less substantial question of law, arises for consideration in this appeal. Accordingly, the appeal fails dismissed. Thank you. Next. Call.
Item number 45.
What I'm appearing for the appellant. 45 sky view. Well, the questions are not at page 7 whether during the pendency of the appeal the assessing officer can re-examine the thing. That was the questions. Lordship will kindly have a look in the CIT appeal has gone in my favor. They have preferred an appeal before the ITAT and ITAT then in this Lordship will kindly have a look in the CIT's order. Lordship will kindly. Paragraph 6 of the Lordship, it is pertinent to mention here that verify the aforesaid aspects of the DR has also called for a report of the assessing officer on the said report. It has been settled, mentioned that while passing the assessment order, under section 150C, the assessing officer, Kolkata, has given the note which is released as under the case were earlier assessed under section 144 of the Act by the DCIT. Subsequently, additions are made on account of share capital amounting to ₹3 crores or not. But subsequently, the unsecured loan of
Mr. Doria, he refers to a report.
Yes.
And in that report, you see what has happened.
Yes.
They have accepted.
Yes.
Has furnished documentary evidence in connection with the receipt of share capital, unsecured loans, expenses, which have been verified and considered while filing the assessment proceeding. Therefore, the tribunal said there is no useful purpose will be send it back to them.
Page 20 of the page 20 of the paper book, Your Lordship.
On the basis of
stay application, Your Lordship.
And
that note of the 153, because the search took place when the original assessment was done. They should not have done it. 153C, they have issued.
All right.
And the notes, Lordship may see the note not for this.
This appeal filed by the revenue under section 260 capital of the Income Tax Act 1961 within bracket the Act is directed against the order dated 25th May 2023 passed by the Income Tax Appellate Tribunal A Bench Kolkata within bracket tribunal in ITA 482/KOL/2022 for the assessment year 2012-13. The revenue has raised the following substantial questions of law for consideration. A and B, para 7, page 7, words also. After elaborately hearing the learned advocates for the parties and carefully perusing the materials placed on record, we find that the learned tribunal had taken note of a report called for from the assessing officer, wherein it has been mentioned as follows. Sir, page 37, the italics portion alone, 37 and 38. Considering the above factual position, the learned tribunal held that the addition made pursuant to the original ex parte assessment, which are subject matter of the appeal before the tribunal, are not sustainable and accordingly ordered the same to be deleted. We find there is no substantial question of law, much less substantial question of law arising for consideration. Will dismissed. Next.
Item number 46.
Lord, I'm appearing. This is a serve, my lord, was returned back with the endorsement. Assessee cannot be located. Assessee cannot be located.
Oh, Income Tax Department cannot locate the assessee. This is penny stock.
Yes, my lord.
Must be penny stock. Because Miraj D. Shah appeared.
Yes, yes, yes. I think Mr. But may I
And Damani.
Yes, yes. So if your lordship is, their entire thing was given, Lord, in the page number 36, not the proceedings were given unsecured.
All right. Fresh notice to the assessee to the
Email,
correct
sir.
address.
Email address also.
In addition, the department shall also serve notice through email in the registered email ID. Next.
I'm grateful, Lordship.
Item number 47.
My lord, I tried to serve, but this has been returned.
Returned?
Addressee cannot be located.
How this is happening, sir?
Then, my lord, pursuant to order under section 263, the assessing officer had passed the assessment order, made an addition under section 68. That was challenged by the assessee. CIT appealed the assessment order.
Some judgment the tribunal has extracted. What is that judgment? Recently, this tribunal in Minax Suppliers has adjudicated similar set of facts and circumstances.
My lord, the findings start as page 35. The tribunal has held that the assessing officer has not expressed his opinion on the explanation given by the assessee. My lord, can we come to page 26, the assessment order, my lord? Para 3, my lord.
Para 3.
Para 3, para 4, my lord. The assessing officer has given his.
And the tribunal, what did it do? It just extracted some decision.
My lord, my lord.
No, a tribunal has it discussed the facts of the case?
My lord, not entirely, my lord.
Page 31, para 8. No, please come to page 34, para 11.
My lord.
Did the revenue have any opportunity to
Controvert these facts, my lord? No, because assessing officer, before the assessing officer, nothing was produced. No, the summons were issued, but the directors did not appear.
No, 263 order was issued.
Initial, that was prior to my lord, sir.
Oh, the notice was returned, addressee cannot be located. Tribunal did not examine the documents. 63. Notice is being returned. So they should have at least called for a remand. They could have called for a remand report.
Yes, my lord.
This appeal by the revenue filed under section 260 capital A of the Income Tax Act 1961 within bracket they are directed against the order dated 13th April 2023 passed by the Income Tax Appellate Tribunal A Bench Kolkata within bracket tribunal in ITA number 26/KOL/2019 for the assessment year 2008-9. The revenue has raised the following substantial questions of law for consideration.
Page 9, my lord.
Page 9 and 10, 1 to 4. We have heard Mr. Amit Sharma,
Read by Mr. Rai, my lord.
Om Narayan Rai and Leonard and Amit Sharma for the appellant SSC. The Commission of Income Tax, Kolkata 2 within bracket CIT, passed an order under section 263 of the Act dated 30th March 2030, pursuant to which the matter went back before the assessing officer and notices were issued to the assessee. Initially, the assessee was represented by a chartered accountant. Subsequently, notices were issued to the directors, which had returned with the postal endorsement within inverted comma addressee cannot be located. The assessee did not produce any documents before the assessing officer, nor the existence of the directors were established before the tribunal, before the assessing officer. So he is not appealing. What happened to the notice? It is returned unserved.
Yes.
Left or what?
Addressee cannot be located.
All right. You take fresh notice, let us. Next. Let's write it off.
Item number 48 with 49 and 50.
My lord, 48, my lord, is appearing first time I am filing affidavit of service. And this is also donation to human genetics and population health. Well, I don't know, my lord, who is appearing, but the PS Magnum and Mr. Orient with who is appearing. Three matters are analogous. I subbed, but
But I'm appearing in not this matter, my lord, for in other two matters, my lord.
Other two matters.
I've been instructed to appear. At this matter, my lord,
This coal sale company is different from the
yes.
PS Magnum.
Yes.
All are three different companies.
But point is, issue is same, my lord. And two matters, Mr. Dhuduria is appearing. And PS Magnum is, I'm led by Mr. Khaitan, so I'm praying time. So in
all right.
Here, the donation amount is less 10 lakhs. PS Magnum is 5 crores somewhat. Mr. Khaitan will argue that PS Magnum. These two matters, Mr. Dhuduria is appearing. So, coal sale, my lord.
Coal sale, your lordship, has been I'm not, my lord, they have served.
I can give him a.
No, if your lordship can regularize, then, my lord, otherwise, my
lord. We have heard Ms. Swapna Das, Siddharth Das for the appellant, Ms. JP Ketan, so on so. Since in the connected matters, namely ITAT 228 of 2023 and 229 of 2023, wherein identical issues arise for consideration, Mr. Prithvi Doria, Leonard Senior Standing Counsel, is appearing for the department. We have directed Mr. Prithvi Doria to accept notice for the respondent department in this appeal, and his appearance be regularized by the department. List all the matters in the monthly list of March.
Grateful.
Next.
Lordship, kindly fix on monthly list of February.
No, February is full, madam. House full.
Item number 51.
51. Your appeal. Fateh Chand, Chandalia.
Lord, here, my lord, issue is the, my lord, the assessment year 2011-12. My lord, initially, my lord, section 143(3) order, scrutiny order has been passed. Thereafter, my lord, 143, 147 also, my lord, passed. Thereafter, my lord, 260 order has been passed on the ground that the investment made in the, my lord, penny stock companies, my lord. Now, your lordship, kindly see.
But did you reopen the assessment for that
Yes,
Tuni textile?
Milord, Tony Textile, your lordship kindly remember that is penny stock, Milord, in the matter of Milord Sati Bajaj, Milord, Tony Textile was there.
Oh, that batch it is
Yes.
there.
Now the point is that Milord, before the Milord tribunal, there is a fresh point taken by the Milord SSC on the jurisdictional issue, Milord, that the reopening is after 6 years time bar. But it was initially not placed before the AO, not placed before the Principal Commissioner Income Tax when we are issuing the notice under Section 263, and in the reply of the under Section 263 notice, no mentioning. First time, Milord, the point of judicial has been taken, Milord. Now, Milord, the Act says, law says, Milord, when the income of escapement is above 1 lakh, 6 years is there. And Milord, I am relying on judgment of the Honorable Division Bench of Bombay High Court, Milord. I have, Milord,
We'll come to the judgment on facts, whether it is time barred or not.
No, on fact, it is not time barred because the Milord escapement is more than 1 lakh.
No, the tribunal in page 28. Moreover, the original assessment proceedings under 143(3) stood completed on 26/2/2014.
Yes, Milord.
So what is the limitation?
Now, 6 years.
My lord, this is assessment at 11/12. And my assessment was for 11/12 was completed on 26/2/2014. Now, if the assessment is being reopened within 4 years, when the original assessment is completed under Section 143(3), then there has to be an allegation in the reasons itself that there was failure on the part of the SSC to disclose fully and truly all material facts. This is what the Honorable Supreme Court has also decided now. The latest ITR I have got. In my reasons recorded, there was no whisper that there was any.
No, that is on the second point. On the first point, that the revision order under 263 is time barred. What he says is 6 years.
That what I say, sir, that this is also covered by the Honorable Supreme Court in Alexandrian for the reason that reopening was done on some other issue, not on the issue which was involved in the original assessment order, not on Tony Textile. That was reopened on the issue of some investment made in some shares, that it was not disclosed. That was properly explained and the ITO dropped the proceedings. So on the original assessment, the issue was there of Tony Textile, but in the reassessment that was not there. So Honorable Supreme Court in Alexandra's Finance has said specifically that whatever was there in the original assessment, for that limitation cannot be taken after reopening the assessment on some other issue. And I have given that judgment by law 293 ITR page 1. I have given the copy of the judgment on the earlier occasion before your lordship.
Your lordship, kindly see, Milord, 263 order, Milord. It is starting from page 100, page 14.
No. Here, whether the doctrine of merger will apply, it won't apply.
Doctrine of merger will apply when, Milord, new material has not been found. Here, it has been found that the, Milord, your lordship, kindly see for once, Milord, page 14, the 263 order, first paragraph, second paragraph.
Yes.
During the financial year 10-11, the SSC also had capital gain to the tune of rupees such and such buy of sale of shares of Tuni Textile. As per information available, shares of Messrs. Tuni Textile is also regarded as penny stock. It was not there in the earlier. The SSC claim exemption under
original assessment 143(3) completed, reopened under 147.
Yes.
On what issue?
Reopening, my lord.
That is the point which is
yes,
the Purana is raising.
And that is there in para 3 of the tribunal's order. What was the issue in the original assessment? What was the issue in the reopening? Para 3 of the tribunal's order, my lord.
On global capital market.
My lord.
Yes.
The said investment was not reflected in the return. So
it is observed from the record that
SSC explained the source, accepted the explanation. As completed their own. Thereafter, PC80 invoked his revision jurisdiction and held that apart from global, how it can happen.
You also kindly see that it is observed from the record that the SSC made investment in penny shares, global capital market limited. Penny shares, thereafter, or semicolon is there. Therefore, 260 proceeding has been invoked. You also kindly see page 10, first paragraph. it has been observed from the record that the SSC made investment in penny shares, the Global Capital Market Limited. Here the lacks of inquiry. And very surprisingly, the SCC did not place the jurisdiction point before any authority. Even we have seen in these proceedings of matter, the jurisdiction points has taken in the time of final order of the tribunal.
There is a comma, sir. Investment in penny stock, page 10.
My lord,
Comma, global market.
investment, my lord, investment, not no long-term capital gain. They say I made investment in global market.
The Tuni Textiles is a penny stock company covered in that Swati Bajaj batch.
My lord, the reopening was on particular issue that the reasons are there with my lord.
That's why 263 proceeding has been invoked. At the time of reopening.
No, you show the reasons for reopening.
Reasons for reopening, that is not.
My lord, these are the reasons. There is nothing
Please
like
show.
that.
No, that is also appearing from the order passed on 28/12/2018.
You see, it is penny stock scripts of global capital. Second paragraph. $293 ITR.
My lord, I have given the copy on the earlier occasion.
And then it is there in the case file.
I got one copy here.
293 ITR.
Kindly look into page para 15, my lord. Alexander Finance. Para 15, my lord.
I am relying on judgment of Bombay High Court. I have not shared.
This is Supreme Court.
Relying the judgment of the Honorable Supreme Court, and that is also affirmed by the Honorable Supreme Court.
All right. This appeal by the revenue under 260 Capital A of the Income Tax Act 1961 within bracket the Act is directed against the order dated March 16, 2023, passed by the Income Tax Appellate Tribunal A Bench, Kolkata within bracket Tribunal in ITA 185/KOL/2022 for the assessment year 2011-12. The revenue has raised the following substantial questions of law for consideration. Question of law, sir. Questions of law A and B, page 5. We have heard so and so. After elaborately hearing the learned advocates for the parties and carefully perusing the materials placed on record, we find that the learned tribunal was fully justified in following the decision of the Honorable Supreme Court in the case of Allegendra Finance CIT versus Allegendra Finance Limited, 2007 293 ITR, page 1 within bracket AC. In paragraph 15 of the judgment, it has been held as follows. So please extract this. The tribunal examined the facts of the case and found the doctrine of merger will not apply and the period of limitation would commence from the original assessment and not from the reassessment, since the latter had nothing to do with the said item of income. Thus, we find there is no error in the order passed by the tribunal. Accordingly, the appeal is dismissed. Substantial questions of law are answered against the revenue. Next.
Item number 52.
I was leading in this matter.
Yes,
Mr. Rupul Kundalia. Item 52.
Your Lordship, item 52, Mr. Avatosh Mujumdar is appearing for the respondents in for some personal work. He is out of station.
All right, you manage.
Your Lordship, I am not briefed in the matter, Your Lordship.
Why are you not?
Large share premium. All right, at the request of the learned
for not
advocate for the respondent.
But I am appearing for the
appellant. Put it in February or March. Put it in March.
But it can be pass it over, short matter.
Short matter,
Yes.
pass over. Next.
Item number 53.
Your Lordship, Mr. Mujumdar is out of station.
Pass over means pass over for the day.
Lordship, grateful.
It's already done.
53.
56. 53, 54 already. It has been tagged with another matter. Avanta Realty.
Item number 56.
In this,
Six Lordship, I'm appearing for the other opposite party. I'm being led
this
by
is my
Advocate
application,
Sampson.
Your Lordship.
He's not present to the appearing for not.
On the last occasion, there was a direction for, we have taken a point with regard to the one, because 143.2, the notice was issued. And that was, that issue, notice was under challenge. That the jurisdictional officer should have issued, but there was a different jurisdictional assessing officer has issued it, my lord. So there was a direction for submitting another question of law. May I have a?
You give him
This is
a copy.
draft question of law, my lord.
This is addition or redrafted?
This is in addition to the earlier one, my lord.
The learned advocate for the appellant
And we have served the assessee the additional question of law.
has filed additional substantial question of law, copy of which has been served on the learned advocate for the respondent assessee, who seeks time to get instruction. List in February. Next.
Item number 57.
This is my application, my lord. There is a delay, my lord.
I think
Right,
delay is
condoned.
condoned already. Delay condoned. Delay already condoned.
Your lordship kindly comes to page 6, my lord, the question of law. 57. 57. Mid-sealer. Yes.
Lord, I'm appearing for the respondent.
Once again, sir. Some 263.
My lord,
Yes, my
if
lord.
your lordship
Coming
kindly
in-
takes up the matter, my lord, I was in personal difficulty. That is why I was late to the court, my lord. Only, my lord, Wednesday, my lordship takes up, my lord. My lord, I'm ready with the matter, my lord. But
All right. We'll say pass over.
my lord, I'm extremely grateful. I'm extremely grateful.
The tribunal says it's a debatable issue.
Yes, my lord.
Correct.
It's on this
Not only
particular
that,
issue.
my lord, on merits also, I'll satisfy your lordship. On Wednesday, my lord.
The dark question of law is that whether this section 1038 issue can be a debatable issue or not, my
No, my
lord.
lord, it is not that, my lord. I'll satisfy your lordship on next day, my lord.
Because of the amendment, my lord.
My lord, your lordship will kindly
2015
find
amendment,
that-
my lord.
See, there are two views. The AO has adopted one of the view.
And your lordship has also taken a view, my lord, on 263 aspect of the matter, my lord. I'm not only handicapped by the not with the matter.
No, we'll dismiss the.
And barcode 263 down.
Please come. This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961 within bracket the Act is directed against the order dated March 28, 2023, passed by the Income Tax Appellate Tribunal, C Bench, Kolkata within bracket Tribunal in ITA 259/KOL/2020 for the assessment year 2017-18. The revenue has raised the following substantial question of law. Questions of law for consideration, page 6 and 7, A and B, heard so and so. The short question involved in this appeal is whether the Principal Commissioner of Income Tax could have exercised jurisdiction under section 263 of the Act. The learned tribunal has elaborately considered the factual position and noted that there were two views possible which could be taken by the assessing officer, and the assessing officer has taken one of the view. Thus, the tribunal came to the conclusion that the jurisdiction under section 263 is not available to the PCIT when a case is a debatable issue. In this regard, several decisions have been referred to by the learned tribunal, and in particular, the decision of the Honorable Supreme Court in Malabar Industrial Company Limited and Max India Limited. Thus, we find the conclusion arrived at by the tribunal cannot be faulted. The result, the appeal is dismissed. Substantial questions of law and set against the revenue.
I'm extremely grateful.
Next.
Item number 58.
58, 59, my lord, I'm praying not today.
Not today.
58 and 59.
Not today.
Item number 60.
May it please the lordships, I am appearing for the respondent.
This is my appeal, my lord. My lord, the 263 order was passed by the PCIT. Against that order, the SSC filed appeal before the tribunal. My lord, tribunal held that the principal commissioner has not made any specific observation. Why? As to why 263 provision under section 263 should be invoked. This is the crux, my lord. My lord, can we come to page 40 of the tribunal's order, my lord? I'm reading out the from middle portion. Learned principal CIT in the impugned order has only given a general observation that the learned AO has not conducted the necessary inquiry. But in the impugned proceeding has not given any specific finding as to what was the information which the learned AO has not called for and also has not given any comments. Which the learned principal CIT was required to call for during the course of revisionary proceedings. My lord, I kindly come to page 23, the PCI 263 order, my lord.
But the tribunal says there was no specific finding.
Yes, my lord, that's why, my lord. Kindly come to page 23, my lord.
23.
Yes, my lord. Here the PCIT has discussed all the facts, my lord. Why the invocation of 263 was required? My lord, in the just a Walter Investment Private Limited example, the SSC has shown that the SSC had taken loan from Walter Investment Private Limited. But in another proceedings, my lord, of the group company, it was held that the Walter Investment is a paper company. There was an audit report, my lord, which I have annexed.
Please come to page 39, para 10, tribunal finding.
My lord.
Where is the assessment order?
Assessment order, my lord, at page 12.
Now, if after 142, one notice issued, questionnaire given, the assessee responded, he appeared through authorized representative, several dates of hearing had taken place, they had filed submissions, and then documents, books of accounts, bank statement, and then only the AO finalized the assessment. Para 10 and 11, how will you get over? Tribunal's finding. Page 39 and 40.
My lord, here even the unsecured loan, the SSC has shown that their interests were paid. but in reality, no interest was paid. And it's a Walter Investment, my lord, is a paper company.
No, that's what the tribunal in page para 10 says. Walter Investment for which closing balance on 31/3 is 1,29,000 increased to 32 lakhs on 31/3/40. There is a fresh loan of 30 lakhs from Walter Investment. Similarly, there's a fresh loan of Pratyush Consider at
My
rupees
lord,
10
can you
lakh.
see if the company has 30 lakh odd, can the company give a 30 lakh loan to another company? When the company will grant loan, my lord.
Milord, my very respectful submission is, Milord, page 39, paragraphs 10 and 11. Milord, kindly see the questions framed. The second question framed, they admit there is an inquiry. They are not happy with the kind of inquiry given. It is, in my very respectful submission, there are a catena of judgments which say, and that is the trite law, that you cannot direct them to inquire in a specific manner. Inquiry is done, that's recorded. And that's paragraph 10 and 11. In fact, may I read out paragraph 11, Milord? Because this, Milords, in my very respectful submission, answers the query. We notice that the learned AO has called for all the details of unsecured loans taken by the SSA during the year and has also referred to the seized material in notice issued under 142(1) of the Act, and all necessary replies along with the evidences have been filed during the assessment proceedings. It is not the case of no inquiry. Rather, it is a case where the learned assessing officer has raised necessary queries with regard to the issue under consideration, and on being satisfied with such details and accepting the identity, creditworthiness, and genuineness of the cash creditors, took a plausible view as provided under the Act and completed the assessment proceedings under 153A, read with section 143(3) of the Act. Learned Principal CIT, in the impugned order, has only given a general observation that the learned assessing officer has not conducted the necessary inquiry, but in the impugned proceedings has not given any specific finding as to what was the information which the learned assessing officer has not called for, and also has not given any comment on such information which the Principal Commissioner of Income Tax was required to call for during the course of the revisionary proceedings before holding the assessment order in question as erroneous and prejudicial to the interest of the revenue. We therefore are of the considered view that since sufficient inquiry has been conducted regarding the unsecured loans taken by the SSE during the year and detailed submissions have been filed by the SSE, we find the assessment order passed under 153A, read with 143(3), dated this is
Difficult.
neither erroneous nor prejudicial. Now, Lord,
Appeal by the revenue under section 264 also is directed against order dated 23rd February 2023, passed with Income Tax Appellate Tribunal, A Bench, Kolkata, in ITA number 1126/KOL/2019 for the assessment year 2014-15. The revenue has raised the following substantial questions of law for consideration. Page 8, 1 and 2, heard so and so. The short issue which falls for consideration in the instant case is whether the Principal Commissioner of Income Tax was justified income tax, Central 1 Kolkata within bracket PCIT was justified in his invoking his power under section 263 of the Act. The learned tribunal, upon going through the facts, has recorded the following finding. Please quote paragraph 11 of the order, page 39 and 40. From the above factual finding, it is seen that the tribunal was satisfied that it was not a case where the assessing officer has not conducted any inquiry. The tribunal on facts found that the assessing officer has raised necessary queries with regard to the issue under consideration and was fully satisfied with the details furnished by the SSC, and also accepted the identity, creditworthiness and genuineness of the cash creditor, and took a plausible view as provided under the Act and completed the assessment under section 153 capital A, read with section 143 within bracket 3 of the Act. The learned tribunal also faulted the PCIT for making a general observation stating that the AO has not conducted the necessary inquiry, but and failed to give any specific finding as to what was the information that the assessing officer had not called for, and has also not given any comment on such information which the PCIT was required to call for during the course of revision proceedings. before holding the assessment order in question as being erroneous, prejudicial to the interest of revenue. Thus, we find there is no substantial question of law arising for consideration is dismissed. Next.
I'm deeply obliged, my lords.
Item number 61.
I'm appearing. Late time Tilok Mitra, my lord. This case, my lord, will return back with endorsement associate cannot be located, my lord. This is also
Fresh
returned
notice to the
to
respondent.
the respondents. Email service also, my lord.
Email, etc.,
Late
etc.
time Tilok Mitra.
Put it in March. Next.
Item number 62.
I beg to appear for the appellant, your lordship. There is a delay of 62 days.
I think it is condoned already.
No, it's not condoned.
One second, let us see. Delay not condoned. Who will appear? Amit Sharma will appear. Amit will appear.
We have served, your lordship.
In the state petition itself. You can accept notice, no?
If pilot direction.
All right. We have heard Mr. So-and-so, learned advocate for the petitioner. We have directed Mr. Amit Sharma, learned standing counsel, to accept notice for the respondent department, and the department shall regularize its appearance. There is a delay of 62 days in filing the appeal. We are satisfied with the reasons given, and the delay is condoned. The learned advocate for the appellant is directed to serve one set of papers
Your lordship.
on Mr. Amit Sharma. Put it in March. Next.
So brave.
Item number 63.
Appear for the appellant, your lordship, there's a delay of 22 days in filing the instance.
Respondent.
We have served the respondent filing by.
You can accept notice. Mr. Kundali can accept notice. We have heard Mr. So-and-so, so-and-so. We have requested Mr. Vipul Kundalial and senior standing counsel to accept notice for the respondent department. The appearance of the learned counsel be regularized by the department. There is a delay of 22 days, same order, condoned. Put it in March.
Written.
We'll stop.
Item number 37 was passed over.
Passed over for the day.
But if that may be taken up on Monday or Monday.
It will remain in the list. Passed over means it won't go out on the list.
Wednesday or some difficulty.
That day we will see.
I'm ready.
Yes, sir.
With respect to item number 75, today's date, my lord, is extremely urgent situations, my lord. The accounts of the SSC has been seized. My lord, his business has come to an halt. My lord, we have not been given any opportunity of hearing, and
who will appear for the respondent in item 75?
But we have served, but
no,
we
you are
have put them on
appearing as
notice, my lord.
I am
Mr.
should have
Bhaskar
identified.
Prasad Banerjee. Mr. Bhaskar Prasad Banerjee.
Where is
My lord,
Banerjee?
put them on notice also, my lord, with regard to mentioning on Wednesday, if not taken today. But my lord,
Let it remain in the list. You inform Mr. Banerjee, saying that you mentioned, we may take it up earlier. Yes, Mr. Kohli.
Sir, can you allow me to file a rejoinder to the written note or arguments of the appellant?
You please give one copy to Mr.
Yes, sir, I've got it. I'll give it.
Yes.
It's filled with lies. That's why. No, I mean, documented, sir.
All right.
My lord, item 66 and 68, this is my appeal, my lord. The company's name has been changed. That's why we couldn't serve it, my lord. They can adjourn for fortnight, my lord. By that time, my lord.
All right. Item 66 and 68. Mr. Uday Shankar Bhattacharjee, learned advocate appearing for the appellant, submitted that the name of the respondent company has changed, and the appellant will take out appropriate application for amendment of cast title. So enable notice to be served. Let the matter be listed February.
My lord, item number 44.
Yeah.
Our name may be incorporated, my lord, because it is from our chamber only, your lordship. Subhash Agarwal and Associates.
Item 44.
Item 44.
Please record name of Mr. Subhash Agarwal and Brijesh Kumar Singh.
Deeply obliged, your lordship.
Yes. Okay. So to afternoon, what to do? Appellate say 2:30 will come and see. 2:30 sometime we will come.
Appellate side, daily list, serial number 1.
Serial number 1 is an appeal for non-prosecution, my lord. There is a restoration application pending. Kindly restore the matter, and I'm not pressing the matter.
Lord, I am appearing on behalf of private respondent.
There is no delay in the filing the application.
Yes, my lord.
Yes, there was, and that's
There
why
was
a
delay.
restoration application is. No, there is no delay in filing the appeal.
And what is the matter?
My lord, the matter, the impugned order, which is the order impugned in the appeal, is with respect to the alternative remedy, on the ground of which the writ petition was dismissed. Under the Bengal Excise Act in the respective rules in respect of the same. Now, the writ petitioner or the appellant herein is the owner of an off shop of the liquor, country liquor. So at present, my lord, he doesn't wish to proceed forward with the appeal anymore.
So we will restore and then permit you to withdraw the appeal.
Not pressing the appeal.
Not
pressing. Dismissed as not pressed.
We have heard so and so. Rules given in the application for restoration and being satisfied, the application is allowed and the appeal is restored. Committee number so and so. The learned advocate for the appellant has instructions from his client to not press this appeal. Accordingly, the appeal stands dismissed as not pressed. Yes.
Deeply affirmed.
Serial number 2.
What is the correction?
At the instance of the appeal, matter has come.
Matter is being listed under the caption to be mentioned. It is noted that there is no CAN application pending and therefore CAN 1 of 2024 as mentioned in the order dated 9/1/2024 stand deleted. The matter was listed on 5th March 2024, but inadvertently it has been shown as 5th March 2023. The same shall stand corrected. This order shall form part of the order dated 9th January 2020.
Grateful, man.
Yes.
Serial number 3.
And I beg to appear for the writ petitioner respondent, the Cooperative Bank. I am led by Mr. Mukherjee, who is online.
Yes, sir.
I beg to appear on behalf of the writ petitioner respondent.
Yes.
The appellant is the Punjab National Bank, Lord.
The impugned order, in this case, has come to my lord hold that my lord the appellant before your lordship, my lord has ultimately received fixed deposits, my lord from the West Bengal my lord State Cooperative Bank, but has refused to pay them back. So my lord in a writ petition there is a direction my lord on the bank to my lord make this payment. Now my lord with the greatest of respect, my lord perhaps my lord a few things my lord have been lost sight of my lord in the course of my lord ultimately coming to the conclusion as to one whether there has been, my lord, in fact, receipt of my lord this fixed deposit amount at all. My lord, before I, my lord, come to open the papers, may I just tell you, lordship, very briefly. Representation is that the West Bengal State Cooperative Bank, my lord, approaches the Punjab National Bank, my lord, the Punjab National Bank, my lord, saying that they're interested in opening a fixed deposit. My lord, Punjab National Bank, my lord, indicates an account number. Well, in that, my lord, money is RTGS transfer is made. And my lord, so far as that is concerned, later, my lord, they come forward and they, my lord, realize that something is amiss. And they call upon the bank to, my lord, disclose the particulars of, my lord, the fixed deposit held. And the bank says that, no, this money is, my lord, ultimately taken away by one Lakshmi Commercial. Now, my lord, there is obviously, my lord, a fraud at play. Now, lord, interestingly, before I open you lord, the papers, the same situation has happened between my lord, my lord, West Bengal State Cooperative Bank and 2 other banks. Now, lord, I can well understand that my lord, the officials of PNB have my lord conspired to my lord defraud the West Bengal State Cooperative of my lord this sum of money. But my lord, it is very difficult to imagine that exactly the same situation is repeated with two other banks, because my lord, this was one of the three writ petitions that had been filed by the State Cooperative Bank in this regard. Now, my lord, what I will be able to show to your lordships from the papers, and of course, my lord, this matter will have to be heard ultimately, is that, my lord, here, my lord, the request
Now
was...
we are hearing the appeal.
Yes, yes. Now, my lord, kindly have a look at, my lord, some of the documents. My lord, the question is, my lord, how does this transaction take place, and whether, my lord, one can say that the loss, my lord, is entirely on account of the Punjab National Banks. I have to accept that, my lord, some officials of the Punjab National Banks were a party to this, my lord, entire collusion. But, my lord, this could not have been done without the active, my lord, participation of, my lord, officials of the State Cooperative Bank also. My lord, that is what I would like to show you, lordship. Now, my lord, kindly have a look at, my lord, some of the documents. My lord, if your lordship will please have a look at, my lord, page 117 first. Now, my lord, this is a form by which an account was opened by, my lord, the gentleman who represents Lakshmi Enterprises with the Punjab National Bank. Well, if your lordship turns the page, comes to page 118. My lord, this is a clearer copy. Well, your lordship will find that the account number ends with 40286. Well, account number ends with 40286. Well, this is Lakshmi Commercial Bank's account opening form with the Punjab National Bank. Kindly see the date. Well, the second last row, 22nd of December 2012.
Yes.
So, 22nd of December 2012, this Lakshmi Cooperative Bank opens this account, Lakshmi Enterprises opens this account with the Punjab National Bank. Now, thereafter, if your lordship sees, my lord, kindly have a look at, my lord, page 66 now. Well, at page 66, my lord, is the proposal, my lord, by Punjab National Bank, allegedly. Now, my lord, kindly see, very interestingly, my lord, this document is supposed to be the document on the basis of which my learned friends were induced to invest. Now, my lord, kindly see, 17th January 2013. Now, my lord, kindly remember that 22nd December 2012, this Lakshmi Enterprises opens this account. 17th January 2013, Punjab National Bank is supposed to be writing to the West Bengal State Cooperative Bank. And my lord, kindly see what it says. We are furnishing the rate of interest on your proposed bulk deposit of 10 crores. And the above for the period as under, for 1 year rate of interest will be 9.65% per annum. Then, my lord, branch name, Punjab National Bank, Salimpur branch. Next, our bank deposit account number, my lord, is 40286. This is, my lord, Lakshmi Enterprises. Now, my lord, no bank, my lord, will possibly say that deposit the money in the account of someone else. Now, my lord, this is a manufactured document.
Oh, my lord, I'll ask you to argue this. This documented admitted document. How we can say this now?
My lord, let us understand, admitted to the extent that yes, the document is on record.
In the affidavit, there is no denial of this document.
Let us, my lord, just let me make my submissions. Your lordship will decide the matter. So, my lord, now, my lord, on the 17th of January, that is a few days after the account is opened by Lakshmi Enterprises, Punjab National Bank is calling upon, now, my lord, kindly see who, not the West Bengal State Cooperative Bank Limited, because, my lord, the name is the West Bengal State Cooperative. It's calling upon West Bengal State Cooperative Bank Limited and calling upon them to make this deposit, my lord, in, my lord, an account which is an account of Lakshmi Enterprises, and, my lord, gives the IFSC code, my lord, which obviously is the code of Lakshmi Enterprises. Now, my lord, thereafter, my lord, what follows, if your lordship kindly sees page 70. Well, the typed copy is at page 71. Kindly have a look at page 70. Well, this is the RTGS that is being made.
Yes.
Now, let kindly see page 71. It is more legible. Well, this is 24th January 2013. So, my lord, sequence of events. Account opened by Lakshmi Enterprises 22nd December 2012. Proposal, my lord, made by Punjab National Bank on 17 January 2013, and this RTGS is made on the 24th of January 2013. Now, my lord, kindly see, my lord, RTGS, it says, made on 24th January, then kindly see the value date. My lord, if your lordship travels down the page, transaction reference, and value date, currency amount. Value date is 24th January 2013. Amount is, my lord, 20 crores of rupees. Ordering customer is, my lord, now the West Bengal State Cooperative Bank Limited. Now, my lord, most interestingly, my lord, the beneficiary customer account number is 40286. Now, my lord, West Bengal, my lord, State Cooperative Bank is, my lord, saying that this is the beneficiary. And then, my lord, kindly see, name and address. Whose account is this? The West Bengal State Cooperative Bank Limited. So, my lord, West Bengal State Cooperative Bank Limited is saying that I'm making an RTGS in an account in the name of West Bengal State Cooperative Branch Limited with this, my lord, account number. Now, my lord, the question is, my lord, today, if I just pause here for the moment, my lord, is it conceivable that, my lord, the West Bengal State Cooperative Bank Limited is misled into believing that it has an account in the Punjab National Bank with this account number, with this IFSC code, and it is making the transmission to this account? My lord, that is where, my lord, the whole, my lord, thing lies. My lord, there is, my lord, no doubt. There is, my lord, some, my lord, collusion and conspiracy between, my lord, both, my lord, bank officials and, my lord, state cooperative officials. And this, my lord, is something that, my lord, ultimately, my lord, amplifies itself in, my lord, the same situation that has happened before between this bank and, my lord, two other banks. Now, my lord, what follows thereafter is also very interesting. Kindly see page 72. My lord, this is the fixed deposit receipt that is supposed to have been granted. So, my lord, the bank, my lord, grants a fixed deposit receipt, my lord, to the West Bengal State Cooperative Bank on account of a deposit made to Lakshmi Enterprises. My lord, that is what they're saying. They're saying that this is the document under which you have an obligation to hold the money in deposit and to pay it back to us. Well, kindly see, this is Punjab National Bank writing to the general manager. Again, my lord, the D is missing. This is on the 4th of February. 24th January is the, my lord, RTGS. 4th of February is the fixed deposit receipt. And says FDR at the rate of 20 crores for 1096 days. That's 9.65% per annum in favor of account number such and such. We enclose here with original fixed deposit receipt for 20 crores for 1096 days. My lord, thereafter, my lord, kindly see page 75. Now, my lord, this happens on the 4th of February, and page 75 where your lordship will find that suddenly, my lord, there is, my lord, a lot of, my lord, interest in this. I request you, my lord, barely a month thereafter, the West Bengal, my lord, State Cooperative Bank writes to the branch manager of Salimpur branch of Punjab National Bank, I request you to kindly confirm the balance amount of fixed deposit received with the face value of 20 crores issued to your branch on 4th February 2013 with effect from 24th March 2013, bearing number such and such enclosed, remitted by us through RTGA under UTR number such and such, my lord, which is that 40286. My lord, they ask for, my lord, confirmation so far as this is concerned. My lord, now, my lord, naturally, my lord, this cannot be confirmed. Now, my lord, kindly see, my lord, in this context, my lord, what happened in the background also. My lord, this, my lord, is my learned friend's cause of action saying that you have said that this is not available with me. What had happened in between? Kindly have a look at, my lord, page 134. Your lordship will remember that 24th January 2013 is the RTGS. Now, my lord, kindly have a look at page 134 now. Now, my lord, this is a letter which, my lord, Punjab National Bank, my lord, has written saying, we are to inform you, this is 28 January, 4 days after the RTGS, regarding request for confirmation of RTGS of 20 crores. In favor of Lakshmi Enterprises. So, my lord, they had made this RTGS in favor of Lakshmi Enterprises because that is the account number. Now, my lord, when this RTGS comes in, 4 days thereafter, my lord, the bank is writing to the West Bengal State Cooperative Bank saying that we are to inform to your good self that the captioned amount, that's 20 crores of rupees, was credited to account number 40286 of Lakshmi Enterprise on 24 January 2013 through RTGS done by you. Please let us know the purpose in details as the account is a newly opened current account. Please treat the matter as most urgent. And then, my lord, the response, well, if your lordship sees 135, I'm sorry, the very next page. We have received your letter dated 28 January 2013. We have issued RTGS of 20 crores in favor of Lakshmi Enterprises, account number 04286, my lord, on account of construction of hospital.
This is the first
First installment will be issued RTGS.
We will issue further RTGS to the above.
Yes. Now, my lord, this is, my lord, what happened. So, my lord, sequence of events. My lord, I have shown to your lordship. And my lord, what is most interesting is, my lord, this 02486 account, my lord, is ultimately not an account of the State Cooperative Bank. It is also not an account, my lord, which is a deposit receiving account of the Punjab National Bank. But, my lord, when the RTGS is made, the RTGS is made specifying that number. Beneficiary account, my lord, then account number is mentioned. And it is mentioned presumably on the representation of the Punjab National Bank in its proposal letter, saying that please pay it into this account. My lord, which is something that, my lord, is inconceivable. Now, my lord, I would have understood that, my lord, there is fraud, collusion, conspiracy, etc. My lord, here, my lord, the question of vicarious liability would then come in naturally. But, my lord, at this juncture, my lord, the question is, my lord, whether this could have been done, my lord, independently, my lord, only the bank. And what is the explanation for the similar situation happening with other banks also? Now, my lord, here, if your lordship now sees, well, this is something that has been lost sight of entirely in the impugned judgment. When the learned single judge, my lord, comes to the conclusion that no, you have received fixed deposit, you have to pay it back. Now, my lord, if your lordship will kindly have a look at now, my lord, the impugned order. I don't want to trouble your lordship with other documents.
What is the prayer in the writ petition?
Well, the prayers in the writ petition, your lordship will find at page 61. Let me show your lordship the prayers. Refunding, returning sum of 20 crores deposited on 24th January 2013 in the form of fixed deposit for a period of 3 years with interest, my lord, at the rates. That is the principal prayer.
Yes.
Now, well, so far as the impugned order is concerned, if your lordship will kindly now have a look at the impugned order once. Lord, may I request your lordship to kindly have a look at it from, my lord, paragraph 4 onwards. My lord, internal page 2, bottom of, my lord, the judgment.
Judgment of memorandum.
Yes.
Well, pursuant to and in terms of the said offer or proposal made by the Punjab National Bank on 22nd January 2013, first petitioner reviewed the same and found that the said proposal of the first respondent was with the maximum available rate of interest at 9.64% per annum for a period of 1 year. Thereafter, further negotiation was held by and between the first petitioner and the first respondent, when it was agreed by and between the parties that the first petitioner would invest a sum of rupees more than 10 crores, but not more than 20 crores for a period of 3 years at the same rate of interest. Then, my lord, kindly come to the next paragraph. The first petitioner then on 24th January 2013 duly remitted and deposited a sum of 20 crores in favor of the first respondent through RTGS. Now, my lord, this was not in favor of the first respondent. This was in the account of Lakshmi Enterprise. Well, then if your lordship skips over the rest of it and kindly have a look at paragraph 6. After the said deposit being made at the account of PNB, the third respondent, being the senior manager PNB on 4th February 2013, through its forwarding letter, duly issued necessary certificate of the said fixed deposit bearing account number such and such, with effect from 24th January 2013, showing the maturity date as 24th January 2016, and the sum at maturity would be rupees 26 crores 35 lakhs 18,454 for 93. Then, my lord, kindly comes to the next paragraph. The petitioners thereafter came across some news from the daily newspaper regarding some disputes relating to fixed deposits arose out of fraud with UCO Bank. Now, my lord, this is another bank. Same, my lord, situation. UCO Bank, Circus Avenue branch, Kolkata. The first petitioner then, by its letter dated 20th March 2013, requested PNB to confirm the balance on account of the said fixed deposits for a sum of rupees 20 crores. In response to the said letter on 21st March 2013, the first petitioner received a letter from PNB issued by one Mr. A.C. Shaha Shodhar, branch manager of the Salimpur branch, where for the first time the petitioner came to know that PNB had not opened the said fixed deposit account bearing the said account number such and such at this branch in favor of the first petitioner for the sum of 20 crores. Well, thereafter, your lordships will kindly have a look at paragraph 11. Despite demands made by or on behalf of the petitioners, the first respondent failed to return the fixed deposit amount to the petition. Well, then, my lord, kindly straight away, my lord, come to paragraph 30.
What happened to the criminal case?
I'm sorry, my lord.
It's submitted.
Well, so far as criminal case is concerned, my lord, one official, I think, of PNB was arrested. Some recovery was made from him.
Recovery made, yes.
And my lord, made over to the scope. Now, my lord, this is, my lord, what the learned judge ultimately holds. On a careful scrutiny of the documents appended to the said pleadings, 30.
Which paragraphs?
My lord, I'm now taking lordship now to 30 because essential facts, my lord.
Yes, we saw page para 27 onwards, the decision.
Yes, that's right. Now, I would request your lordship to kindly have a look at paragraph 30 at page 20. On a careful scrutiny of the documents appended to the said pleadings filed by the parties, it appeared from Annexure P1 to the writ petition, the said document was issued by senior manager of PNB, providing the details and particulars of the account number and the IFSC code of the particular branch of PNB, at which the writ petitioner was asked to deposit the money for creation of term deposit or fixed deposit. PNB also promised the rate of interest as 9.65% per annum payable to the first petitioner. The petitioner was asked to issue a check in favor of PNB and deposit the money in account numbers 40286. Annexure P3 to the writ petition was a transaction reference document showing the deposit of 20 crores made by the first petitioner on 24th January 2013 in the same account number for a term of 3 years at the said agreed rate of interest. This was a document generated electronically evidencing the deposit made by the first petitioner with the first respondent. Annexure P4 to the writ petition is a forwarding letter dated 4th February 2013 issued by PNB enclosing the original fixed deposit receipt for the said sum of 20 crores for 1096 days. The FDR account number was mentioned as such and such, and the branch serial number was mentioned at 177000. This document was signed by the senior manager of PNB. The appended document thereto was the copy of the original FDR, which contained the title as confirmation of deposit. The branch was mentioned as Salimpur branch, Kolkata. The branch serial number is 177000. The FDR account was mentioned as such and such. The date of issue was mentioned as 24th January 2013. And the date of maturity was mentioned as 24th January 2016. The maturity value was mentioned as 26 crores 35 lakhs 18,453. Invested amount was mentioned as 20 crores. Document was signed by two authorized signatories of PNB and was signed by both of them on 24th January 2030. Then, my lord, if your lordship kindly has a look at, my lord, paragraph 33.
Affidavit opposition needs to be read.
Page 22 and 23.
Yes, my lord. Upon a careful scrutiny of the averments made by the parties and the evidence disclosed in support thereof, There was no doubt that the term deposit account was opened and the said sum of 20 crores was deposited by the first petitioner through RTGS in the specific bank account as was provided by the first respondent. And the first respondent, by using the said original fixed deposit receipt, unequivocally accepted, confirmed, and admitted such deposit. Annexures P1, P3, and P4 to the writ petition were not in any way challenged, questioned, rebutted, or controverted by the first respondent. The first respondent also did not deny and challenge the issuance and existence of the said documents and the power and authority of the signatures thereof, save and except a bare evasive denial of Annexure P4 for the sake of denial, which was no denial in the eye of law. These documents, read with the relevant developments made by the parties in their respective pleadings, clearly showed that the first respondent had received the sum of rupees 20 crores from the first petitioner with a promise to pay interest thereon at 9.65% per annum as per term deposit fixed deposit. The mode of transfer was RTGS, which was automated system and platform generated under the control and authority of the ninth respondent. Then, the next paragraph. Till the time the said Lakshmi Enterprise alleged to have utilized and withdrawn the said amount, the first respondent was the custodian of the same. This is something that I have not been able to really gather. On March 20, 2013, when the first writ petitioner requested the first respondent for confirmation of the said term deposit, the first respondent, by his letter dated 21st March 2013, informed that the said fixed deposit was not available in the name of the first petitioner, and even the first respondent did not take any step whatsoever as a trustee and or custodian of the said sum for not allowing the said third party Lakshmi Engineering to withdraw the said sum or any part thereof from its bank account maintained with the first respondent or probe into the issue. Well, thereafter, my lord, if your lordships.
No, the learned judge proceeds on the basis that annexures P1, P3, P4
yes
was not denied,
Yes.
was not challenged.
Well, it was
That's
not
the
challenged, but
basis.
my lord, here, my lord,
More than
kindly
three
see.
places from page 22 onwards, the learned judge heavily relies upon that. Therefore, he says if those documents remain uncontested, there is no question of adjudication of this claim, there is no disputed question of fact, therefore pay.
Yes, my lord, with the greatest respect, my lord, only one small question arises.
No, just straight away let us come to the crux of the issue.
Yes, ma'am.
Exhibit P1, P3, and P4
Yes, ma'am.
are the documents at page 66.
My lord, P1 is 66.
P1 is 66.
Yes, my lord.
P4 is 72.
Yes.
And
Well, one thing, well, only one thing.
no, P3, where is P3, sir?
Page 70.
FDR.
Well, this is the RTGS.
Yes. Now, what was your stand in the writ petition regarding these three documents?
Now,
of course, it is rather very surprising that the bank will write to soliciting deposit, but this appears to be a very big amount. So, in fact, before 31(3), all these bank managers go canvassing. Please give some
No,
deposit.
that was in response to our queries. We sent queries to the bank, they replied.
My lord, I am not for once saying that, my lord, there was no, my lord, fraud. I am only saying that, my lord, today it was not really, my lord, something that the bank, my lord, ultimately, my lord, called upon them to pay into, my lord, the bank account. My lord, let us
You could have taken a stand. Exhibit P1 is a concocted document. You could have filed a police complaint alleging that the letterpad of the bank has been misused, etc. Probably fraud has been played, but everything is through proper channel.
My lord, may I, my lord, only say this?
So you pay and recover.
My lord, it's not, my lord, with respect, my lord, it is perhaps not that, that is perhaps not the case. Now, my lord, when my learned friend, my lord, they are saying what? They are saying that I called upon them to make payment into this particular account. My lord, which was admittedly the account of Lakshmi Enterprises.
You could have sent a corrigendum or a communication saying that it should not be towards that account.
We will.
My lord, what we did is, my lord, the documents that your lordship has seen, my lord, which are at, my lord, pages 134 and 133, 133 and 134 and 135. My lord, we had immediately written to them saying that we have deposited such a large sum of money.
17 January.
Why did you not deny these documents? If your lordship see, my lord, pages 134, 135. My lord, 24th January is the RTGS. My lord, 28th January, we write to SEM that why have you made this payment to the account of Lakshmi Enterprises to the newly opened current account? And my lord, they say that we have made it as payment of first installment for construction of a hospital.
You should have stopped there.
Was there any communication prior to 17th January 2013?
Prior to 17th January 2013, my lord, I have not, my lord, come across any communication. My lord.
Because this 17th January says, we are here with furnishing the rate of interest on your proposed bulk deposit.
Yes.
So the offer should have been come from them.
Well, offer, well, that is, well, not a part of the record. At least I was not there before the single judge, but I have not found these, well, that in the, well, records of the appeal.
They propose, you offer.
Well, that is, well, what it seems, but because it is something, well, that is in response to their proposal, but their proposal subject to correction is not on record. Well, kindly see page 37, well, in this regard. Paragraph 3, this is what they write in the writ petition. Well, paragraphs 2 and 3. Petitioner Bank, West Bengal State Cooperative Bank is required to deploy its excess funds in fixed deposits of commercial banks as interbank investment, investment in consortium finance, purchase of bond, commercial deposit, investment in collateral borrowing, and lending obligation. Then, the Punjab National Bank Selangpur branch, under reference of letter dated 17 January 2013, sent a proposal through fax to Managing Director of West Bengal State Cooperative Bank for the bulk deposit of 10 crores and above for the period of 1 year with interest at the rate of 9.65%. Well, there's
That Lakshmi Enterprises was a party to the proceedings?
no. Lakshmi Enterprises was not.
Where is your affidavit in opposition?
Well, I'll tell you. Well, that is 109. Paragraphs, my lord, 4A onwards. Paragraph 14, there is denial, my lord, about exchange of communication.
I request you also to look paragraph 6 of the affidavit.
But with this RTGS, when you make a transfer, it not only asks for the name of the bank, recipient bank, IFSC code, account number, branch code, name of the account holder.
Yes, name of the account holder.
So, if the name of the account holder is the West Bengal State Cooperative Bank, in your data, the name is Lakshmi Enterprises. How did the cash come in? Electronically, it
Well,
can't
the
be
cash, my lord, if your lordship, my lord, kindly once again comes back to the RTGS form, my lord, page 71. Now, ordering customer is West Bengal State Cooperative Bank. So, my lord, they're going to make the RTGS. Then, my lord, kindly see beneficiary account number. My lord, account number is 40286. And then kindly see name and address the West Bengal State Cooperative Bank Limited. Why did they, my lord, make the RTGS to this? Well, let us assume everything against myself. My lord, when you say
No, they transferred it means if this was an FDR, fixed deposit, it should be in their name. So therefore they say account number is this.
Right.
my lord, this account number was not their account number.
I don't know.
No, it is sent to them by at page 66, exhibit P1. They
But
were
they-
informed that you please deposit in 40286.
Now, my lord, so far
They
as
probably presume that it is their account number.
no, my lord,
But
they-
then one thing, you before see, can a person who does not have a current account or a savings account, can he have only a fixed deposit in your bank?
my lord, there is, I have understood from the instructions received that, my lord, the bank can refuse the deposit in, my lord, a deposit receiving account from which it issues the FD.
Yes. So therefore, a prerequisite would be the FDR holder should have an account. It should be either a savings account or a current account.
That's right.
So what he says is, you have given me this number 40286. They presume that it is the West Bengal State Cooperative Bank account. I transfer it to that account.
Right.
From there, you transfer it to an FDR account,
Well,
and that automatically generates interest. Is given.
well, with the very greatest of respect, well, there are two things, well, that immediately, well,
No. Why we wanted to see the affidavit in opposition is what is the stand taken by the bank in respect of 17-123 communication.
well, if your lordship kindly sees, well,
2030.
what it says, my lord, by way of explanation before the parabolic dealings at page 109, well, it, my lord, explains that, my lord, this was account of Lakshmi. Now, my lord, today, my lord, naturally, there is, my lord, manipulation of documents, my lord, when a fraud is, my lord, carried out. But, my lord, here, at the end of the day,
No,
this
fraud is by officers of PNB.
my lord, fraud is, my lord, by officers of PNB, my lord, which could not have been carried out without, my lord, the participation of the West Bengal State Cooperative.
No
And,
such
my lord,
allegation.
your lordship will see, this is for the same reason that they say the same problem has arisen with UCO Bank.
What happened to that UCO
Well,
Bank?
This petition is pending.
Well, a writ petition pending
Honorable
similar.
single judge has kept this matter, and
Well, there are
thereafter this
two.
matter will be taken.
Well, there are two matters. One is UCO Bank and the other is Indian Overseas Bank. Same identical situation.
Did you raise the issue regarding maintainability of the writ petition?
No. It was raised, but, my lord, learned judge has discussed the question and he says, my lord,
In
that
your
ultimately,
affidavit in opposition?
I'm sorry, my lord.
In your affidavit in opposition?
No, I find that it was raised in the course of arguments. I find that, my lord, this was raised in the course of arguments, but, my lord,
That should have been your first.
a lot of things, my lord, should have happened, my lord, which I find have not happened. My lord, I can only, my lord, apologize to court for that. But, my lord, at the end of the day, my lord, the question is, my lord, whether, my lord, this is a situation, my lord, kindly see UCO Bank, Indian Overseas Bank, Punjab National Bank, everyone has committed the fraud in the same manner. Everyone has, my lord, invited them to make fixed deposits, given an account number, which is not the account number of the bank, which is not the account number of the account holder. And, my lord, today you have to open an account. My lord, how can you be so gullible?
Where is the charge sheet in the criminal case?
Yes,
Only one information, the PNB branch manager was arrested 6 crores and odd has been recovered from him and some ornaments.
And
Mo-
that's
Motor cars, two motor cars.
Given to them.
That has been given to us. But so it is recovered from him.
180 charge sheet.
My lord, charge sheet is not a part of, my lord, the appeal papers. My lord, we don't have a. That's it. 180. I'm sorry. I'm sorry.
Recovery 189, 190. No, this is charge sheet 180.
No, charges, final. It's a keyboard, sir. Page 180.
180.
180.
Recovery page 81.
Page 185 may be, my lord, important. Also 190, my lord, if you lordship.
It a recovery also.
Who is original? Who is original?
The fact that it's about 6 crores was recovered and paid back to them goes without saying it's their money.
No, well, there
Otherwise,
is,
you could have kept it in deposit and said that till the outcome of the criminal proceedings, I will not pay it to you. It's very, very unrealistic because their transfer clearly said the account, the name of the account holder is the West Bengal Cooperative Society.
it is not their case that, my lord, it was represented to them that this account, my lord, would be an account, my lord, because an account number is assigned, pre-assigned. My lord, it is pre-assigned to them. Now, my lord,
Therefore, fraud has been played.
yes. Now, my
Fraud
lord,
has been played.
my lord, what the charge sheet, my lord, reveals is part of a very organized racket.
Yes, all
And
the
my-
officers of the bank, Punjab National Bank.
No, my lord, not only that. Now, my lord, here, if your lordship, my lord, calls for the records of the other two writ petitions from what we could gather, identical. My lord, identical matter.
It's a racket.
Yes. Now, my lord, today, my lord, in 3 banks have defrauded, my lord, the West Bengal State Cooperative Bank of, my lord, various sums of money. And my lord, in an identical fashion. My lord, could it have been done without, my lord, their participation?
No.
There is no affidavit to that extent.
Because the West Bengal State Cooperative Bank Limited is an apex bank. It is registered under the Cooperative Societies Act.
Yes.
And it is an entity by itself.
Right.
Like Punjab National Bank is an entity by itself. You are a scheduled bank. The officers are different from the entity.
Yes, yes.
So it is the entity which has come to the court for some fraud may be committed by its own employees, committed by the employees of Punjab National Bank.
Well, I am very grateful. Well, now that your lordship has asked me the question,
we have received a letter and we have issued RTGS also in favor of. You asked him.
Yes, Mr. Basu, what do you say about the letter at page 135?
Just oh, this is a story to cover up the Lakshmi. These two, there is a.
This is not issued by you. This
No, not at all. Letterhead is not mine. That has been dealt with by the Honorable Single Judge. And this letter is also forged. This PNB letter. 134, 135, both are forged.
My lord, that is your stand in the.
Yes, yes. That has been taken care of by the Honorable Single Judge.
In the reply.
In the reply.
Which
Because
paragraph?
this is
Which paragraph?
paragraph. I have to show to you. Give me 2 minutes time. To the entire building, na? Kindly come to the letterhead first. In the meantime, he is finding. Kindly come to my letterhead 135.
135.
Our letterhead is West Bengal State Cooperative Bank Limited, Waterloo Street. Entire building is ours, not ground floor. Our letterhead does not depict ground floor.
Mr. Basu, kindly read out the affidavit and reply.
I'm sir, I'm trying to assist.
Para 7.
Para 7, page double
153.
153.
Our reply.
Yes, mark. It's my lord, paragraph 7.
7.
153. With reference to statement made in paragraph 4, I deny the material allegations contained therein 7 which is a matter of record. And it is strongly denied that the letter as relied upon by the respondent bank through NSB3 allegedly issued by the cooperative bank. It is categorically denied that those letters referred under rule R3 and R5 were ever issued by the petitioner bank. The petitioner bank is known as the West Bengal State Cooperative Bank Limited, who in the letterhead does not bear the names written West Bengal State Cooperative Bank. The position of logo of the bank in the letterhead is also different. The petitioner bank never issued such letterhead. Moreover, the petitioner bank never used the telephone number as mentioned in Annexure R3 and R5 of the affidavit in opposition. The communication as referred to being Annexure R3 and R5 undated communication. The petitioner bank never issued any letter without mentioning the specific date as per the existing and standing policy of the petitioner bank. And the petitioner bank always use memo number, reference number in all its communications, but in the letters given in R3 and R5, no such reference are there, and the signature as shown in the R3 and 5 alleged to have been made by an employee or officials of the petitioner bank is also fictitious, and such as the document appearing in R3 and R5 are forged and prepared by the respondent bank in order to support their baseless allegation. There.
Any admitted letterhead of yours is
Yes, I can.
in this.
Yes, I'm
on record.
Just Ache.
Page 78.
78. Where we are asked for the
77.
Kindly come to 77.
পুরোটাই building টা।
Enter building is the this
is your letterhead, admitted.
Admitted letter. And kindly this point was taken by the Honorable Singh. See, registered office and head office, Waterloo Street, Kolkata. একটা দেখালি তো।
Well, let's kindly see once page 66 months. Well, this is the document on which they relied in making the deposit. Now, it says our bank deposit account number. So the representation is that this is the account of the Punjab National Bank deposit account number. Then, kindly see the last line. Check should be issued in favor of Punjab National Bank, account number such and such.
In this account, we have deposited.
No, you have furnished the account number where the deposit is to be made. This was your proposal.
Now, very interestingly, I would have appreciated that they are misled if they do this. We say that please deposit a check in this account number, and this is account of the Punjab National Bank deposit account. The RTGS that is made in the name of, as my lord the Chief Justice was pleased to point out, in the beneficiary account number 40286, and then name and address West Bengal State Cooperative Bank Limited.
Yes.
So normally,
called parking account. Something is called parking account.
It will not match. The transfer will not take place except for the fraud committed by the bank official. Otherwise, it will never get into the account.
But till today, there is no allegation against our employee. Till today, there is no allegation.
All the accused are all bank employees.
Bank employees and several others.
And you can withstand this 20 crores. They can't withstand.
It is, at the end of the day, it is not a matter of my withstanding. The law is, today I accept that, the bank officials must have played a part in the fraud. But, I also, say, with some amount of, conviction because of the manner in which things have done, that it could not have been done without their complicity.
Fraud has been committed.
Now,
probably their accomplice may be in the cooperative bank also. But here,
here the law is that, when both parties are equally to blame, the loss lies where it falls.
We have not blamed up till now.
No, here what we have said in our affidavit.
My lord, there is no such allegation in the affidavit in opposition. No such point made out with the onward trial.
No, my lord, that is paragraph page 107.
Fact remains the amount was transferred. That's all. That is not in dispute. Whether the advice was, whether somebody siphoned it off, whether your officials colluded, your bank officials, the cooperative bank officials colluded, it's a question which is not before the writ court. The writ court, the bank came to your bank, not to your officials, saying that we were asked to make a deposit in this account. Now you say this account number 7044086 or something like that is Lakshmi Enterprises. This is a matter, they have lodged a police complaint, charge sheet has been laid, matter will take its course. In the meantime, they want them to be secure. So please refund the money. Part of it, 6 crores has come to you. The remaining you try to recover and pay, subject to the ultimate.
The cooperative bank, poor man's money. All poor people are depositing the money here.
My lord, in the trial court, no allegation against the state bank, cooperative banks officials.
বলেছি.
That is correct.
My lord, Punjab National Bank officials, my lord, ultimately practice fraud.
And page 73 document also is not disputed.
73. No, this is never disputed. FDR never disputed.
And
That's
the
the finding of the
FDR
honorable trial judge.
Pardon, sir?
That is the finding of the honorable trial judge.
Okay.
Page 73 is not disputed.
Page 73 not disputed. FDR issued in the name of the cooperative bank,
Yes.
not in
Not
dispute.
disputed.
All right, sir, we will consider.
But only one, my lord, very small, humble prayer. My lord, if your lordships, my lord, don't find favor with this appeal, my lord, I've been directed to make this deposit. Now, my lord, a contempt proceeding has been taken out against me. My lord, I had, of course, challenged this order in appeal. My lord, in that case, my lord, kindly extend the time for me to make deposit. If your lordships, my lord, are
Contempt proceedings.
2nd February is the next date. In view of the pendency of this, the court has, though rule issued, thereafter stop there.
Stay has been granted.
No.
You can pray for adjournment there. In case we are not able
No,
to
if
deliver,
my lord has heard is make it CAB, so I will pray for it.
we have heard so and so, judgment result.
And my lord, also, my lord, there appears to be no credit given for the 6 lakhs of rupees that has been recovered. My lord, the learned single judge has directed, my lord, payment of the entire money within.
Less the amount already
No,
paid.
that my lord probably subject to criminal proceedings. I don't know. But
No.
now the deposit with us. If ultimately criminal case not in our favor, then he have to refund.
No. Suppose we confirm the order, the amount to be refunded or returned back will be the amount less whatever has already been given.
I mean, the deposit amount, not the maturity value.
No,
Not the
interest has
maturity.
to be.
What has been asked to be
Yeah.
given?
Well, the maturity value.
date?
Maturity value have to. It is poor man's money.
What is
Bank
the
will
maturity
hold
date?
up.
What was the maturity date?
That maturity date was 2015. 16, 2016.
So it has matured to 26 crores or something.
And thereafter interest. Otherwise, my lord,
And
bank
on
cannot
that also,
survive.
and on that also interest. My lord, I can understand, my lord, lordship directing, my lord, refund of the deposit that has been made. Now, my lord, this has been siphoned off, my lord, with their complicity, without their complicity, my lord, your lordships are not going to that. But at the end of the day, my lord, 6 crores credit will have to be given, and my lord, also deposit amount will be
All
returned.
right, we'll consider.
Kali considered that it is a cooperative bank, the poor man's money. If the money is not with us, bank has to know already wound up. Entire money has been deposited, excess amount.
Yes, sir. Next.
Serial number 4.
Yes.
I will prepare for the respondent, my lord. I have let Mr. Devnath Ghosh. My lord. Here, my lord. I am for the ECL authorities, my lord. In this, my lord, in our contract, my lord, we have, my lord, clause, my lord, that if the contractor does not complete, my lord, the 80% of the agreed rate, then we can blacklist him, my lord. We can blacklist him. My lord, may I hand over? He's leading.
Lordship permits.
Yes.
Very short point, my lord. Contract is for excavation of coal, removal of overburden, and my lord, excavation of coal. My lord, it's my lord, a contract which specifies that unless 75% of the work is done, my lord, then my lord, under the general conditions of the contract, clause 9b, my lord, the employer can, without terminating the contract, there's a peculiarity of the clause, without terminating the contract, can blacklist the contractor from performing any other contract only with ECL, not with other coal companies, not with other millard authorities, nor there is enough power to millard basically circulate this to all state authorities under the contract. This is done, millard, for the purpose of ensuring improvement of the work of the contractor. A chance is given. So if you successfully execute this particular work,
the banning order, which was for 3 years, can be reduced, can be revoked, etc., etc. Millard, it's a case, Millard. There was a land given, Millard, to the contractor to carry out work. Millard, in these coal mines and areas, Millard, there are some land agitations in question, which is, Millard, the order of the day of our country, Millard. Wherever there is a land, there is a dispute, there's a Bachao committee. If the coal is extracted, there will be villages will be disrupted, there may be fire, etc. Don't do blasting, etc., etc. So there was a Sidulu Bachao committee, Millard, in Asansol, which, Millard, had raised, Millard, said that you cannot carry out the overburden exercise. Millard, and the work was stopped from the hindrance. There is a hindrance register. Millard, that, Millard, gives an option to the contractor, Millard, to apply for extension of such term. The contractor today, Millard, cannot come up and say that I will not work. Millard, he is free to not to work. Millard, in this contract, Millard, it's all contracts, Millard, are, Millard, terminable in nature. So, Millard, this type of contracts, now, Millard, he is free to work. But that does not bar the authority, Millard, to, Millard, proceed against him in terms of the contract. Now, Millard, 3 show cause notices were issued. Only 2 is on record, 1 was not produced. And, Millard, 3 replies are there. There is also an FIR, which is admitted. I also, ECL went forward and said to the superintendent of police and, Millard, the other police authority, please take steps so the work can go on, because unless coal is there, Millard, there are various difficulties. And ultimately, it's not a case of blacklisting without show cause notice or without giving any personal hearing. Millard, personal hearing was given, and, Millard, there are question answer 3 or 4, Millard, 3 of them, which says the contractor comes forward and says, yes, I can carry out the extraction, but there may be problem at the time of blasting. Thereafter, Millard, no order has been passed. I'll show the order, which says, Millard, these grievances of the contractor or the grounds of not working are found to be satisfactory, and he was banned for 3 years. With being aggrieved thereby, a writ petition was filed, and in the motion stage, a writ petition was allowed, saying, Millard, A, there is no objective satisfaction in the banning order. Deepest of respect, Millard, I'll show the grounds. The case of objecting satisfaction has not been made out. The case of impossibility was made out. Impossibility is what? There is no land, I cannot work, so give me back my the security deposits, the bank guarantee, and let the contract be foreclosed. This was the prayer. This was the argument. Now, Millard, the order of banning has been squashed in toto, in entirety rather, I should not use that word. And, Millard, the contractor has been given a liberty to take part in the future contract. Millard, with deepest of respect, Millard, if a banning order is, Millard, bad, or it's found, Millard, it doesn't have the natural ingredients, the reasons are not there. The normal the courts do carry out, Millard, is, Millard, keep the banning order, A, Millard, proviso A, proposition A, keep the banning order, but reduce the punishment order, period of punishment. B, you set aside the entire thing and you give the authority a liberty to carry out proceedings de novo afresh upon giving any hearing to my learned friend's client and conducting a physical hearing in presence of both the parties. This is, Millard, Kulja developers, Eurasian chemicals going on, etc., Millard. So, Millard, this absolute, Millard, that, Millard, banning order is squashed without giving any opportunity to carry out further acts or, Millard, taking steps as per the tender conditions and general conditions of contract, as well as, Millard, permitting, Millard, that with a mandatory order on the first, at the motions and disposing of, he will be entitled to participate in the tender. This is where, Millard, I, Millard, have to, Millard, argue, Millard. Lordship will kindly take the interim order once, or the impugned order once. Lordship will kindly take.
May I only indicate, my lord, this is not an interim order, this is a final order.
So I said so.
My lord, my friend has said it's an interim order or the impugned order. It should be final order or the impugned order, not the interim order.
Yes, it's the final. Writ petition has
No, let us see the impugned order
Yes.
in the writ petition.
Yes.
Page 119.
Yes, kindly, Millard, takes the impugned order. Banning order, page 119. That's also, Millard, actually Lordship's brief, Millard, 119. It's will at 17th of October 2022. Has my lord found out the page? You were awarded the work of hiring HEM for removal and transportation of such and such, that's overburden, extraction and transportation of 2.1 coal and rehandling of such and such coal. It's schedule IC patch of completion of 1 year, whereas you have not executed any quantity of coal against the target of 1.1 L and executed only 1.7 of the overburden target of rupees of such and such L till achievement, and an achievement of rupees 33, the percentage of 31.33% overburden from December 2021 to August 2022, which is extremely poor performance as per the contract. So, my lord, coal extraction is 0, overburden is below. If you take that, it's only 31% of the overburden. That is what I am stating in the order. As such, schedule OC patch, Kendra, ECL has suffered a loss of such and such, and since December 2021 to August 2022, the area management has requested you to improve the performance of your work and deployment of sufficient number of equipments as per the NIT. In spite of several reminders, there was no initiative taken from your end to meet the shortfall of the target production and the deployment of sufficient number of equipments as per NIT. Due to your poor performance, ECL has incurred huge irreparable loss. Your consistent poor performance shows that you are likely to severely impair production capacity of the company if allowed to do business with ECL in the future. Now, kindly take page 120. Poor performance in execution of the work and non-deployment of sufficient number of equipments as per NIT, clause number 9B of the GCT with annexure 9, clause number 2, 4 and 5 of the guidelines of banning of the agreement. After exercising all efforts by ECL at various levels to improve the performance, a show cause notice of banning of your firm for all constitutions of your joint was issued to the General Manager of Kenda area, Vide number 19th of August 2002. Due to dismal performance, lack of commitment, and verifiable steps and improvement of performance, the reply submitted by you, notice dated 25/8/2022 against the show cause was not found to be satisfactory by the area management. From observing the principle of natural justice, a personal hearing was also conducted on 5th of September 2022 at 6 p.m. So there is a personal hearing. However, representation made by you during the personal hearing was not found satisfactory by the area manager. Therefore, in interest of ECL, there is no option to ban your firm with the partners for a joint venture from participation in near future tenders of ECL under clause 9B of GTC, read with section with annexure 9, clause number 4 and 5 of the guidelines of banning of the agreement for a period of 3 years, keeping the contract alive. So, there is a provision. Contract can be kept alive. You work in the contract. If you improve, I'll take steps. The relevant clause 3 of the guideline of banning of the relating to applicability of the banning is stated for your ready reference. Clause number 3 of such banning, if and when effected, it shall be prospectively in effect only. The effect of banning shall be for future tenders from the date of issuance of the order. However, if the contracting entity is banned after online notification or opening of the price bid, such ban will not be effective for such work. In view of the above, BGM, NSC and its constituent partner, Mrs. Vishwajit Ghosh, and mining and movers and are hereby banned for a period of 3 years from the date of issue of the order from participation in future tender of ECL Eastern Coalfields Limited. So this is the order in the banning. Now, Lordship will kindly take me, Lord, for my satisfaction. The hearing notice in question. That's my lord, very
sorry for interruption. Just before that, can we see clause 9B?
9B. My lord, may I hand up the banning order, my lord? The notice inviting tender, a copy though. May I hand up 2 copies, my lord? This was not part of the writ petition, my lord.
একটা copy দেবেন?
করে দিয়ে দিচ্ছি। Kindly, my lord, have a look at
internal page 22.
Internal page 22. Termination, suspension, cancellation, or foreclosure of contract. The company, page 22 is in the bottom, my lord.
They don't have page numbers.
You don't have. May I just then take it?
No, does not.
Internal page 22, it's on the bottom. Has my lord found out the bottom page? Or may I take out? I'm very sorry, I just handed up. May I just take out? It's clause 9. I'm very sorry. এই তো 22 আছে তো It's at the bottom of the page now.
You are
ওই
seeing the first one.
জজ সাহেবকে একবার দিন, আমি ভাগ করে দিচ্ছি। Lordship will kindly take the clause in question. এখানে ওই personal hearing টা বার কর। The company 9B Miller, the company shall in addition to other remedial steps be taken as provided in the conditions of the contract, be entitled to cancel, terminate the contract in full or in part if the contractor B, 9B Miller, fails to achieve monthly agreed quantity of 70% for a 6 consecutive months or a cumulative period of 6 months within any continuous period of 18 months, 7 except to the extent of non-availability caused by force majeure event or an act of omission of company not according to any default of the contractor. Note, in such cases, the contractor may be banned for a minimum of 1 year. This will not the court, if it is felt is too harsh, so it could have reduced, Miller, I say so, Miller, that Schoolja developers from participating in future tender, but allowing the present business to continue without going into termination of contract. This is what I have exactly done. So 3 years was imposed. The clause says 1. It could have been that reduced to 1, could have been reduced to 6 because I, good, bad, indifferent, Miller, I have given him a personal hearing. I have issued a show cause. He's answered to show cause. As an employer, 3 years could not have been imposed, 1 year. That's the clause. Or, Miller, if the total, Miller, if the process, Miller, the court felt that the total process, Miller, there is some sort of arbitrariness, Miller, or it's not, Miller, conscionable, Miller, could have, Miller, given up, this could have gone, Miller, with a leave, Miller, to take steps, Miller, or draw up proceedings as per clause 9.
Now we will see the impugned order in there.
Yes. Now kindly takes the impugned order once. Prior to that, if Lordship kindly takes page 129 of the petition, Miller, then Miller, I do not trouble your Lordship with all the papers here and there. This is the personal hearing, Miller, which was given. Page 129. The contractor's representative, Sri such and such, all that from 18 September, work will be started. Agreed or not, he has said, Miller, work will be started from 18 September. Page 129. This is, Miller, the minutes. Miller, it's not very well framed, Miller, I'll say so. 9B. Now, are you agreeing to clause 9B or not? Agreed, but there was a land problem.
No, local problem.
Local problem. Commit stoppage of work for which the contractor and his team was not responsible. That Shiduli Bachao committee was there. Then Miller, GM sir told that it is only for banning and not for termination. So we are getting a chance to prove yourself. He said the contractor representatives told that that he anticipates that there will be problem during blasting. So land is there, but there will be problem during blasting. This is, Miller, where I have gone, Miller. Now, Miller, the clause and, Miller, the next page, absolutely, this is part of the order. If your Lordship takes the next page, Miller, I have given him hindrance certification also. Means, Miller, what? The period under which there is, Miller, blockage, I'll give him extension of the contract, but he has to improve because coal, Miller, and the targets have been revised. Kindly take, Miller, the coal target, then I have given him the revised target. Considering the hindrance, but he has to work because coal achievement is 0 and this is, Miller, 31%. One is coal, one is coal, the other is the overburden. This side is coal, kindly take OB is overburden, the other side is coal. Now kindly take coal is 0.
December 21 to August 22.
December 21 to now. To August 2022, coal is 0. So far as overburden is concerned, from this, it's, Miller, 71% initially. So, Miller, he is within time. But, Miller, for cumulative, Miller, 6 months period, it's, Miller, below 75%. That's, Miller, third column. to fourth column on the right hand side. This is part of the order.
What is overburden?
Overburden is the top crust, Millard, which has to be removed. The soil, Millard. Then, Millard, you get to the coal, because if one leaves the coal surface unexposed, there may be there is coal theft, Millard. One has to put in guards, Millard. So overburden is the top soil. So, Millard, look at this is part of the order. This is I've given you improve. I'll ban him. Kindly look at the order. Millard, there are cases, Millard, that if this is proceedings, Millard, this is banning is what, Millard? It's a civil debt to the contractor. For that, Millard, courts have now held you have to give him show cause notice. I have not only show caused him once, thrice. After third show cause notice, which I'll show, Millard, this is there, Millard. I went forward with this, Millard, banning without terminating the contract. Now, Millard, his case is you basically foreclose the contract and give me back all my security deposit because I am not in a position to work. It's a case of frustration of contract. That's how the writ petition is been framed, Millard. Now, Millard kindly takes the impugned order once. Paragraph 2. This is, Millard, argued from the bar. The petitioner through the internal page 2 of the order, the petitioner through the learned counsel say that the urgency of the matter arises from the fact that the ECL has issued tenders in December 2022 with the last date of submission in the third week of December. Council submits that an order of banning requires an objective satisfaction on the part of the authority at a relevant point of time and the places to show that petitioners were unable to satisfactorily complete the work by the reasons which cannot be attributed to the petitioner, namely obstruction caused by local people. The council submits that the impugned order of banning suffers from procedural impropriety and the replies of the petitioner were not taken into account. So, Millard, I should have been given a chance to carry on, Millard, fresh proceedings. Now, Millard, kindly, the learned counsel for ECL submits that the writ petition suffers from suppression of material facts in that a third show cause notice dated 19/8/20 has not been disclosed to the writ petition. This I have annexed and showed to the learned senior single judge. The council submits that the banning order is only in respect of ECL and not other coal companies. The council submits banning order merely enforces the clause in the contract entered into between the parties. The council relies on other documents to show that the petitioners were given a revised target but only could complete 31% instead of 70% of the work. That is exactly what I showed the chart. It is submitted that the petitioners have no cause of action since has not terminated the contract with the petitioner. Now, kindly take Millard, page 3. The issue before the court is whether the impugned order of banning, that's internal page 3, paragraph 4. The issue before the court is whether the impugned order of banning dated 17/10/2022 is arbitrary and should be quashed on the basis. The ground for banning the petitioner for 3 years is alleged for non-performance of the contract and the petitioner failing to execute the target percentage was agreed between the parties. The latter alleges loss suffered by ECL as a result of petitioner's poor performance and with prospect further losses if the petitioner allowed to do business with ECL. The impugned order indicates a decision of imposing penalty of banning has been taken out on 9B of the general terms and conditions of the bid documents, termination, suspension, and cancellation of foreclosure of contract. 9B provides that the company shall be entitled to cancel and terminate the contract if the contractor fails to achieve a monthly agreed quantity of 70% for a period of 6 consecutive months or a cumulative 6 months, save and except to the extent of non-availability caused by force majeure or even the acts and omission of the company not occurring due to due default of the contractor. To note, clause 9B provides that the contractor in such case may be banned for a minimum period of 1 year. The clause hence indicates that failure to achieve the targets for a cumulative consecutive periods indicated above would entitle ECL contract for 1 year. The FIR has been made to the Commissioner of Police, Asansol. FIR made ECL to Commissioner of Police Asansol on 21/21 states that the work has been stopped at Siduli by the miscreants who have stopped the progress of the work, causing substantial loss of 3,000 metric cube of the target removal per day. FIR state that the miscreants who have stalled the work of the projects are neither title holders nor do have land belong to Siduli. This is a land fully belonging to the ECL. The FIR also records an earlier FIR lodged by the ECL as Ondar police station on 15/1/2002. More significantly, a hindrance registration which is a part of the contract was signed by both the parties reflecting hindrance caused to the work of the outsider of August-September on the part of October 2022. Each of these handwritten reports mention dates on which the work was stopped. The petitioner brought these facts to notice of the respondents by 2 replies dated 14/4/2020 and 27/4/2022. The impugned order of banning does not consider the ground raised by the petitioner in these replies. The non-consideration of the grounds read with FIR and the hindered in registration leads to the presumption that was an absence of objective assessment or satisfaction on the part of the ECL on the part of the impugned order of banning. The only reasons given in the impugned order is the petitioner's representations replies are not found to be satisfactory by the area manager. This is the ground alone does not constitute objective satisfaction of the respondent, which is particularly relevant for passing and banning order against the contractor for 3 years, which was done in the present case. Notably, clause 9b provides for a minimum ban of 1 year. Clause 9b presuppose a contractor has a free hand to work but failed nevertheless. Now, clause 9. Para 9, page 5. Considering the materials on record, there appears to be a factual there has been no factual basis in banning applying clause 9b to the petitioner for imposing the ban. The banning order does not give any reasons for imposing ban for 3 years. This I have said, Millard, it's 1 year. Now, Millard, Eurasian Chemicals is quoted. Now, kindly have a look at 11. The contention of the respondent, the petitioners have misrepresented or suppressed vital reason to disclose the third show cause notice is not acceptable because banning was on the basis of the third show cause notice. The respondent's case would not have improved even if third show cause notice have been disclosed. Hence, it is not a material suppression. The action of banning is more unconscionable since the respondents have not terminated the contract and have allowed the petitioner to continue the work. That's the clause. I could have understood, Millard. That, Millard, grounds are, Millard, very vague, Millard, very patchy, Millard. So you give me a chance to issue fresh notice and, Millard, take steps as per clause 9b. But, Millard, 12.
For all the 3 show cause notices,
yes,
his consistent reply was, there is agitation.
Yes.
He is unable to work.
Yes.
He has approached the local MLA.
Absolutely.
Things couldn't get resolved.
Yes.
So he has cited certain reasons for his poor performance.
Yes.
But while considering those replies,
Yes.
etc., all that you say is, you have been requested to improve your performance of the work and deployment of sufficient number of equipment. In spite of several reminders, no initiative taken. How do you say that no initiative taken? He says force majeure.
Yes.
That is why he says, one is you stop the work and that where do you get it? And reschedule the work schedule.
Yes.
Then thereafter he said,
I have rescheduled it, Millard. No defeat. I have rescheduled the full work.
Thereafter he couldn't do anything.
Yes. He first said I'll work from October 2022. Then at the hearing
Ultimately,
he
in
said
August 2022, he wants a foreclosure.
Yes, he wants a foreclosure of the contract. Now, Millard,
should you not address that issue in your reply? I'm sorry, in your banning order.
Yes.
Saying that this is false. We extended support.
If that be so, Millard, on the opening submission, kindly, Millard, now takes Millard.
Now, how long the banning order has been enforced?
Millard, banning order, Millard, the order, kindly, Millard,
for 3 years.
No. Now
the
Learned Council says 1 year. As per 1 year means 17/10/2022 to 20.
Minimum 1 year. That's minimum 1 year. Millard, he could, the honorable single judge, because I did not had an opportunity to file any affidavit. That's neither here nor there. Millard, whatever was there on the basis of papers, Millard, I have argued. Now, Millard, kindly take paragraph 15 once. Kindly have a look at paragraph.
You have gone through the order.
Disposed of by quashing the banning order. If that be so, Millard, I should be left to take steps, Millard, if at all I am entitled to in law. And Millard, kindly take the next one.
You decide his request for foreclosure. His case itself is
foreclosure. I'll decide that request.
You decide the foreclosure.
Yes, I'll give a decision on foreclosure.
The fact that you have allowed him to.
I have allowed him to
run the contract itself shows that you don't want him to get out of the scene. If he is so bad a person, you should have cancelled the contract.
Yes, I could have, but Millard, it says for him, that's the clause, Millard. That's the clause. But kindly have a look.
You're considering, suppose there was some pilferage or manipulation of records to show higher production or some lame excuses, etc., attributable to the contractor.
I have not taken, I could have taken further steps since the appeal was pending.
No, in this banning order, you don't deny the fact that there is an impossibility of performance.
Millard, gave Millard subject to correction. It may be a repetition. a chart, my lord, which is forming part of the order.
Yes.
Where, my lord, revised target states have been given to him, and his target is also there.
He says it's impossible to perform.
He says it's impossibility. Now, my lord, with deepest
You
of
are the
respect,
person who was granted the.
I have granted him the tender. The land is mine. The clause of the tender says, my lord, only, my lord, portion of the, I do not have to give land, my lord, entirety altogether. This is, my lord, a portion of the land. There is a huge land in question. I have to give land in the phased manner. That's, my lord, the terms of the, my lord, contract between
Then
the
there's
parties.
some stadium there he wanted.
Already, my lord, everything removed. There is nothing there today. There is nothing there today. Now, my lord, Sijuli Bachao committee came and the local agitation was there. I have to only give land in the phased manner. That's the part of the contract. That's the part of the contract. I don't have to give him all land because it's a long drawn contracts. So I have to give him land in a phased manner. My lord, there is enough land for him to work. The Sijuli stadium is only a part of an area. My lord. And how can, my lord, I say, my lord, the respondent shall not give effect to the banning order and shall permit the petitioner to participate in future tenders.
He says, in this regard, we have already informed the management by several letters as mentioned above for removal of all difficulties from before commencement of work with apprehension for idleness as a
Say, my lord, there is no hurdle, my lord. Will you work, my lord? Will you work? There is a site visit. There is provision for everything. Now, open eyes, my lord. A contract has been entered into. My lord, there is a provision for site visit. There is a provision of giving land in phased manner. All there is in the contract, my lord.
No, there is no reply for any of his requests. None of his requests were commencing from page number 70.
Kindly, my lord.
75 onwards, we find there is no reply.
Kindly, my lord, have a look. Kindly have a look, my lord. My lord, what I have stated, my lord.
All right, if even assuming we accept your submission that it has to be 1 year, the period is already over. Now, is he able to work now?
My lord, if he wants, he can work, my lord. I have not terminated him. He
No,
can
no,
work.
It is not that way, sir. You can't throw up your hands.
No.
You have given the tender. He says, I'm unable to work because of X, Y, Z problem. You say that either you have to handle that X, Y, Z problem or those problems are your own making. It's not so. Suppose there is no access.
Correct.
Then you give a property which is landlocked. Then you cannot say that, like you will say for the appearing for the bank, as is, where is, as of, whereof.
Oh, remembers the face, my lord. Lordship remembers the face.
So you can't say like that.
My lord,
it is winning of a natural resource.
Today, my lord, may I say, my lord, today there is no impediment, my lord. The stadium removed, my lord, land gone. I am willing to give him extension. Will he work? I am of
That
getting
is
that
up to
offer.
he is pressing for closure, return of his security deposit. You have not decided that because it is under 9B. That's a different aspect.
Yes.
That's a 9B. If you don't do that, he may go for arbitration, etc.
Yes.
But in another side, see, you have not found him to be a bad person. If you are so bad, you
Then
would have cancelled the contract.
So, my lord, I did not take any further steps since I am before the appeal because one of
What
the
is
other
the present position?
Well, I feel very embarrassment, but may I use this word that my learned friend, on behalf of his client, has not only made an incorrect but a false submission. Kindly have a look to this. Contract has not yet been terminated.
Yes.
New tender was issued. Work has been awarded. This is the copy. The copy now. But I have other points to show on the face of the record, other than to show the malice on their part, that the impugned order on the face of the record, my lord, is not sustainable. And I would show, my lord, the ECL being, my lord, possibly has thought himself that I am the favored child of the nation. I being a state, I can do anything. On the face of the record, my lord, I would show the arbitrariness and the order impugned passed without jurisdiction. This is notwithstanding the fact that submission has been deliberately made by the bar that as on the date, everything is clear. Who defers him to come? Well, the show cause was issued in terms of clause 6. Impugned order was passed in terms of clause 9. The show cause was issued by the general manager, one by the general manager, the local mine, one by the area.
Let's see the first show cause.
My lord.
You just tell the page number.
Yes, kindly comes to Millard. Page 116.
দাও তিনটে কন্ট করেছিলাম ফার্স্ট শোকে সব এখানে ঘেটে গেছে সব This is the second show.
Well, I stand corrected, madam. This is the second one.
Second
The
show.
first one is of 11th. May I just?
119.
That's Millard page 119 Millard. No, এটা 119 না।
No, not 109.
এই ফার্স্ট কপি করিয়েছিলাম আলাদা করে। কপিগুলো দাও তিনটে শো কজে।
Page 116 is show cause for.
Millard,
banning
page
of-
116 is
Show
the second
cause-
show, second
Well,
show cause.
116 is the second show cause. Well, it was issued by the engineer in charge. The first show cause of 11th April, it was issued also by the engineer in charge. The third show cause, which is taken place on the impugned order, that was passed, issued by the general manager, Kenda area, and the order passed by the general manager, contract management cell.
May I hand
Hearing
up-
was given by the ex-person, order was passed by the
দাও না,
Z
copy
person.
আছে?
First show cause. My lord, may I?
Not there. Millard, kindly Millard, I Millard have made a bunch. First show cause reply, second show cause reply, third show cause reply, because I am myself Millard confused with the writ petition.
এই প্রথমটা কোথায়?
Millard 11/4/2022, কেন দেবজ্যোতি চারটে শো কজ চারটে একসঙ্গে দেওয়া আছে।
চারটে না, তিনটে show cause.
তিনটের উত্তর দেওয়া আছে। It will be helpful.
Well, may I just?
Millard, first show cause is 11/4/2022.
সব কাগজগুলো লাগাও না কেন তুমি ঠিকঠাক করে?
Reply Millard is the next page, 14th of Millard, April 2022. This is first show cause.
Well, first show cause was issued by the agent. The agent is the first authority. Then, my lord, the second show cause notice, 27th April, which is a part of my lord's brief, was issued by engineer in charge, who is other than the agent. And the third show cause, which has taken place in the order impugned, it was issued by the general manager Kendai.
The second show cause was for banning of business.
Yes, yes.
And
if you see on the top.
Yes,
yes,
okay,
yes.
Yes.
Show cause for banning of business.
Banning. So for the first show cause was also for.
No, that is to say that.
No, first show cause was that you have not deployed.
You have, my lord, so far as it is that you have not taken steps. Well, kindly see the last but one paragraph. A notice under section Roman 4 of special terms and conditions such and such for hiring, removal of overburden such and such is being served to you for reply for 7 days with the date of issuance of this order. Now, the ground is that you have stopped work from 4th April 2022. Then again, machine stopped from 8th April 2022. However, in spite of so many calls, you have replied, the undersigned, you have shown your good gesture by starting the job whenever your machine stopped. It is clearly reflect negligence and lack of impact in such and such, which will procrastinate the production program of the OC patch when the company is running under deep crisis. Now, my lord, I have replied to that, 14th of April. That was not taken into consideration, and
no order was passed.
My lord, not only the just Mr. Ghosh, please. My lord has asked me, my lord Chief Justice, my lord, not only an order was passed. Lordship, kindly see their tricky steps. First show cause issued by agent. I had replied. Now he has not come into the picture. Now the second show cause issued by a different person.
Engineer in charge.
Engineer in charge. Now I have again replied.
Engineer in charge / agent.
Agent.
Now, on the earlier day, it says only agent. Now, my lord, so far as they are concerned, my lord, according to their tender document, engineer in charge is the area general manager. The contract shows that engineer in charge is the area general manager. Now I have again replied, that was not even taken consideration. No counter has been given. The third show cause was issued. I have given, Lordship will see, after the second show cause of 27th April.
Third show cause was
I have replied on the 27th April itself. Lordship has seen.
Third show cause is 19th.
19th of August 2022.
Prior to that, I have given reply.
Yes, 27th April.
27th April. Then they have 19th August. Then again, I have replied. 25th August. And after this 25th August, kindly see, I have deliberated what are the things, which have caused hindrance, which is accepted by them also. And the last page of my lord's brief, the hindrance register that they have shown, they say, my lord may recall, Mr. Ghosh was submitting that from April, May onwards, there was no production. It is admitted that from this April, May onwards, there was a disturbance, was much ongoing. It is admitted by them, So, they themselves not only had admitted, but they have brought a record which also corroborates, their contention. Kindly comes to order impugned.
Today
kindly comes to
has to be
we are not on the 2 days contentions. We can only see, subject to my lord's pleasure, what was the contention had before the learned single judge and what was the positions you have placed before the learned single judge. But according to him, again a deliberation that what is the 2 days condition? 2 days condition also, they have misled your lordship. They say, the weekend today, can you do? This is just the thing that what he has submitted.
We'll continue.
Very well.
We'll continue.
We have heard so and so for continuation of arguments.
I'm sorry, if I put your lordship tough.
Any date, lordship, I'll.
Kindly, keep, because, may I only indicate, that impugned order they have challenged. That is being not complied with. For months together, the appeal is pending. They have not complied. My banning is on.
I was there.
And
before that adjourned by the ground of Mr. Kishore, non-availability of Mr. Kishore Datta. That's recorded in the order.
It is also on the ground that for your non-availability.
No, not
one order is being passed by this court that remains frustrated.
Not at all.
Tomorrow, day after, whenever it commences to lodge. My instructions, Lordship, David, my lord. Our payment has not been made. Our bills are stuck.
No. We are examining other problems, sir.
Lordship, I know.
Because of these two matters, entire half.
I understand.
What about the other admission cases? We are not unable
Absolutely. And only problem, my lord, my chief justice, kindly, forgive me. My lord, lordship can see the clients are cursing because the order is my lord. My lord.
Next day the matter will come.
My lord.
Grateful.
My
We
lord.
are trying to sort it out.
Grateful, lordship. Grateful. My lord, grateful. Indeed grateful.
We also have to be heard.
Indeed grateful. Absolutely, my lord. Absolutely.
করছে কাজ কাজ করছে না কত বছরের কন্ট্রাক্ট ছিল
আপনাকে কপি দিয়েছিস
কোনটা কি কপি দিয়েছেন হ্যাঁ ওটা দিয়েছে
ডুপ্লিকেট আলাদা করে কপি দিয়ে দিবি সাজিয়ে রাখ
দেখো কখন ফিক্স হবে
এরপর দিন থেকে বিপরীত না করে আসিস
Grateful.
Energetic.
I tender apology, my lord, for my lord Chief Justice.
You can never perceive our problem.
No, I can, my lord, I can feel, my lord,
on
but
the
Lordship
light-
kindly also
on the
appreciate,
light-
my lord, that the clients are cursing on us, my lord. He is without livelihood.
Everybody will.
Sir, it's very
My
easy
lord,
for us to
my lord, absolutely.
judgment.
Lordship.
For 3 months, we don't
My
deliver 5
lord.
months.
My lord, one sentence order, my lord, we have handed over those two uploading of new tender and work order. Those two documents, my lord,
The
Lordship.
documents are,
You file an affidavit, we can record it.
yes,
You have received it, we have noted it.
My lord, grateful, Lordship, grateful.
grateful.
Deeply obliged, deeply obliged. Names.